Lord, I have every argument, my lord, every submission and facts are
You
there.
have put in your supplementary.
Yes, they are already there, but I have put it in a little flow so that it's, Lord, easier for me to assist your lordships, my lord, in a.
So should we go through your, because that is comprehensive, so should we go through your supplementary submissions?
Correct.
Okay.
Correct. My lord,
आपके पास है supplementary?
yes, my lord, I'm putting
Right,
a
right.
caveat.
That's why you got.
My lord,
This includes the previous one.
my lord, it is supplementary written submissions.
So therefore, you have taken into account the previous one and comprehensively made this.
Yes.
So this
but
is
there
sufficient. We don't need to
nothing
go
new.
back to the previous one.
One or two legal submissions are new. Otherwise, my lord, they are all repetition, but we found at one place.
Right.
But there is one caveat. Lord, before I take your lordships to the legal submissions, Lord, I would confine to legal submissions only. My lord, why I say this? Lord, certain events are happening, my lord, when your lordships are in the midst of the matter. Some protests, etc., which, my lord, constitutional functionary should always avoid when the matter is before your lordship. I would not answer, but if your lordship would like to know the facts, Lord, we are open. But we thought, my lord, that we would confine to the legal and constitutional submissions, because protest or theatrics can never take place of written submissions before the constitution date. If your lordship finds anything based on, my lord, some news articles being, my lord, recently published, my lord, it's a coincidence, must be a coincidence that since last 8 days some news articles are coming or some protest. My lord, if your lordship would like to know the facts, I'll be very happy to
You
assist.
can't decide a question of constitutional interpretation on the basis of.
Absolutely, my lord. By going into that, I don't wish to reduce.
Interpreting the constitution.
I don't wish to reduce the level of debate before the highest court of the country, my lord, to anything. Because, my lord, whatever happens in the capital.
Dr. Singhvi, we have indicated that this is a constitutional issue.
I have in fact much more to say than he does. I have desisted completely. Therefore, where is the question for this initial
I am
excursion?
not against
I am
Dr.
desisting.
Singhvi. Dr.
I am
Singhvi
desisting.
has
I am much
maintained
more
the
to say,
level
I am
of
not doing it.
constitutional.
All right. So we'll go on with your written submission and we look at the constitutional argument.
Yes, my lord, because, my lord, whatever happens in the capital is seen by the world, my lord, and it's an embarrassment for the entire nation. Therefore, I put a caveat. We have nothing to hide. We'll show if your lordship wishes to. Otherwise, I will go to the constitutional court. Now, Lord, coming to the services. My lord, your lordships on the last occasion, my lord, posed a very pertinent question, which is the heart of the matter. How do you involve or include services within the phrase of insofar as it is applicable to the union territories? So that was your lordship's question. And that's, my lord, precisely the question for consideration. Lord, firstly, and I'll take that, my lord, it is the assertion of NCT of Delhi that services falls within us, falls within them. It is for them to show under which provision services falls within them. Merely showing that it is in the state list, entry 41, and therefore applies to us will not be a sufficient threshold crossing to decide whether services falls within them or not. They have not crossed that threshold, except giving some administrative difficulties, my lord, which cannot be a substitute for a constitutional argument whether this entry falls within union territory or the central government. So, my lord, while saying that they have not discharged their burden, since I am before your lordships, it's my duty to satisfy the conscience of the court that constitutionally it lies with the center. Lord, first and foremost, Lord, we cannot forget, Lord, the argument was we could recall, Lord, 2 days have passed. In fact, that there is a full-fledged state, there is a central government, and there is an intervention not permissible under the Constitution. Lord, my fundamental submission based upon which, Lord, I'll make this submission is that we cannot lose sight of the fact that we are dealing with the capital of the nation, and central government is a major stakeholder in the administration of capital. It's not an intervention of an outsider.
But Mr. Solicitor, you will also still have to deal with the question as to whether recognizing the executive power of the GNCTD over services will detract from the status of Delhi as a national capital territory.
Certainly, I must do that. I must do that. But before that, my lord, I'll have to lay foundation from your lordship's judgment that Delhi has a sui generis character, and therefore it is a hybrid model which is chosen, that some powers are ceded by the center, though it remains a union territory.
Fair enough. Should we because then we can, as we go along, then you can break in the paragraph and then make your submission, so that
Please, Your Lordship.
your submissions have.
Lord, I would, my lord, earnestly urge your lordships to allow me to read some of the paragraphs from the 5-judge bench judgment.
You have quoted them also here.
Yes.
Of course, you can certainly read them.
Yes.
It's like,
I'll not go beyond, my lord, what I have stated here. I can
so
assure you.
let's read through it. It'll also give us a perspective. It'll
Lord,
sort of
the-
help us to.
Yes. My lord, the majority judgment, when I say majority judgment, my lord, numerical majority,
Sure.
because there was no minority.
Minority action.
Yeah, so majority in the loose sense of the term, because there was no your lordships and my lord Justice Bhushan were concurring judgments. But majority does not deal with this crucial aspect, the significance
Of Delhi.
of capital. My lord, the Chief Justice, my lord, was pleased to deal with this, my lord, at page 2, para.
Why don't you read from para 1 onwards? Just read it. It will just help us to sort of sink into the matter, because
Please,
the
sir.
weekend has gone by.
I'm obliged, my lords. The entire argument proceeds as if the central government is interfering in the legislative and administrative field of a full-fledged state, thus violating the federal structure. The entire discussion of majority was in federal structure in a state center context. The significance of
One second. Supplementary.
Yes, Your Lordship.
Today.
Yes, please. Then,
Para 2. The significance of Delhi as a capital and its control by the state government is recognized. Lord, it should be central government. Lord, that's a typo. Para 2, page para 2, Lord, there is a typo, Lord. Significance of Delhi as a capital and its control by the state government. It should be central government. Your Lordship would find that in the context subsequently, is recognized both prior to the constitution and after the constitution. But prior to, I have read, my lord, that the center must keep its control over the capital. Article 239AA is also so structured that while providing for a democratic government in the NCT of Delhi, the major control of the major stakeholder, that is the government of the entire nation, is retained over the capital of the country. The entire issue deserves to be viewed keeping this backdrop in mind. The entire discussion of the majority judgment on federalism, etc., misses this viewpoint, vital point, in the entire discussion on federalism.
Mr. Solicitor, just do this as we go along. Tell your junior, the nodal counsel, Padmesh, who's been looking after this, to make whatever corrections, like state, center, or as you go along, you can do it on your laptop and mail it to the court master. So he'll immediately mail a correct copy.
Simultaneously. But subsequent para
No
makes
problem.
it clear that what I
He'll be able to do it right here, because as you are correcting as you go along, he can correct
Certainly,
it.
we shall do that. I am obliged. Under the title Federalism, Collaborative Federalism, Pragmatic Federalism, and Concept of Federalism and Balance are devoted to issues which can apply only to states. The concurring view, my lord, the Chief Justice, however, recognizes this concept in the judgment so and so. My lord, I'll read para 362. While bearing these fundamental constitutional principles of a democracy in mind, a balance has to be struck with the second of the above elements, which recognizes the special status of the NCT. The NCT represents the aspirations of the residents of its territory, but it embodies in its character as a capital city the political symbolism underlying national governance. The circumstances pertaining to the governance of NCT may have a direct and immediate impact upon the collective welfare of the nation. This is the rationale for the exclusion of the subject of public order, police and land from legislative power and necessarily from the executive power of the NCT. These considerations would necessarily require a careful balance between the two principles. Of the two principles must be given adequate weight, producing a result which promotes the basic constitutional principle of participatory democracy, while at the same time preserving fundamental concerns in the secure governance of the nation. Then, my lords were pleased to in page 389. Undoubtedly, the governance of NCT involves national imperatives. They must also weigh in the balance. The proviso to clause 4 of Article 239 AA is constitutional indicator of the national concern which were borne in mind when the constituent power was exercised, established the NCT as a political arm of the governance by a special constitutional provision. Those national imperatives have led to the carving out of areas of police, public order, and land from the sphere of legislative authority of the Legislative Assembly and their entrustment to the Parliament. But insofar as my lords have said somewhere else, so it's not coming here. Again, it is the sense of national imperative which led to the constituent power being so modulated in relation to the NCT as to allow parliamentary legislative authority over all entries in the state list in addition to the concurrent list. Parliament does not exercise legislative authority in relation to the state list entries as regards the states in India unless a matter falls within the ambit of Article 252 or 253. Parliamentary legislative control over union territories has been broadened precisely as a manifestation of national imperatives or concerns. The executive power of the Council of Ministers being coextensive with the legislative power, this aspect has to be borne in mind. The true challenge is to maintain that delicate balance in a federating union such as ours, which ensures that national concerns are preserved in the interest of unity and integrity of the nation, while at the same time, local aspirations exercised through the democratic functioning of the elected governments find expression in our politics. Then, my lords, the Chief Justice was pleased to observe in 390, the constitutional principle which emerges is that while Delhi presents a special case, quite unlike other union territories, the constitutional provisions governing it are an amalgam between national concerns reflected in control by the union and representative democracy expressed through the mandate of a council of ministers which owe collective responsibility to a directly elected legislature. There is no gainsaying the fact that the control by the union is also control of the president acting on the aid and advice of the Union Council of Ministers, which in turn owes collective responsibility to the Parliament. Constitutional statesmanship between the two levels of governance, the center and the union territory, ought to ensure that practical issues are resolved with a sense of political maturity and administrative experience. This court has to step in only because skirmishes between the two have raised constitutional issues of proper distribution of executive control over national capital territory. In this context, what I said, from 92 till date, with a level of political maturity, though there were different political regimes in center and state, everything worked smooth. Then, my lords were pleased to say at 471, the exercise of the constituent power to introduce Article 239 AA was cognizant of the necessity to protect national interest inherent in the governance of a national capital. A sense of permanence and stability was sought to be attributed to the arrangements made for governing Delhi by bringing in a constitutional amendment, both in terms of the reach of the legislative power as well as in relation to the exercise of executive power. The special constitutional arrangements for Delhi recognizes that the governance of Delhi implicates a sense of national interest. When matters of national interest arise, they would predicate a predominant role of institutions of national governance. Then, my Lord Justice Bhushan is pleased to devote one para. The word capital is derived from Latin word caput, meaning head, and denotes a certain primacy status associated with the very idea of a capital. Delhi is the national capital of the country. For the purposes of this case, it is not necessary to notice early history of Delhi. During the British period, your lordships can skip the history your lordships have seen. Now, Lord, now I am coming directly how I respectfully assist your lordships that services are not applicable to union territories. So those phrases insofar as not applicable. Services vis-a-vis union territories. The Constitution of India very specifically demarcates units of governance of the nation. A perusal of the index would show that the following units of governance are contemplated by the Constitution and separate and specific powers, duties, responsibilities and provisions are made. Lord, Part 5 entirely devoted to the Union. Part 6 entirely devoted to states. And Part 8 entirely devoted to Union territories, which, my Lord, was introduced by 7th Amendment. The Part 8 was introduced by 7th Amendment. The above are the units of governance contemplated under the Constitution, all of which consist of elected representatives and have been given the legislative and corresponding executive powers depending upon the nature of the union. The union which is contemplated constitutionally and is contained in Part 5 of the Constitution represents the collective will of the entire nation, and therefore they have legislative and corresponding, powers over both List 1 and List 3, subject to Article 245. The state which are contemplated constitutionally and is contained under Part 6 of the Constitution reflects the democratic will of only one state, and therefore only those subjects are conferred upon it which concerns the residents of a state. The union territory which is contemplated constitutionally and is contained in Part 8 of the Constitution merely represents an extension of the union, and therefore there is no concept of federalism between the union and its extended area. The union territories are retained under the control of the union because of different strategic significance of each union territory, be it defense or such other significance. Delhi has the distinct significance of being the capital. The union territory, apart from being an extension of the union, is a reflection of will of people residing in the union territory, and therefore its constitutional status is less than that of the state and more than that of the municipalities and panchayats, because they are also units of governance under the Constitution now, after Part 9 and 9E. The Constitution has therefore given a sui generis position to Delhi, being the capital of such a big nation, and has very consciously restricted its powers only to those entries in List 2, which can be applicable to a union territory. There is one only place in the entire Constitution where the supremacy of Parliament is constitutionally recognized by conferring jurisdiction even on List 2 subjects, and that is when union territories are concerned.
There's some problem with this sentence. Perhaps you'll have to recast this.
Last portion.
There is only place in the entire Constitution.
There is only place in the entire Constitution where the supremacy of Parliament is constitutionally recognized. We will rephrase it. What I am intending to submit is that normally Parliament's power is List 1 and List 3.
Yeah, it's List 1, 2 and 3 over UTs.
Yes. Yeah.
That's what you're saying.
That's what I am saying. That is the only place in case of union territory that supremacy is given even in 2. Otherwise, no other unit of governance has this provision. Having given
but Mr. Mehta, it may be difficult to accept your submission that, look, federalism as a concept applies only where the union and the states. You know, there may be also a sense of hybrid federalism where, where even as between the union territory of Delhi and the state and the center, some elements of the federal structure also apply there. May not be to the same extent as in relation to a full-fledged state. But in carving out a constitutional amendment for the union territory of Delhi, that was also in reflection of a certain degree of federal aspiration. So you're right. I mean, it's obviously not a state. So, you know, it doesn't have all the trappings of a state, but it has some trappings of a state. So as to implicate federal concepts, even in the relationship between the center and the union territory.
May I rephrase my submission? Lord, the principle of federalism will not be completely ousted in the relationship between the union and the union territory.
That's
But the principles which govern the relationship between union and the state, that would not be the federalism. It would be, my lord, as your lordships have rightly suggested, a kind of a hybrid federalism with supremacy to the center and, my lord, federal structure, constitutional earmarks under Article 239.
Why do you postulate federalism? I mean, as an abstract constitutional theory, federalism implies when you don't have a unitary form of government. That is, you have a demarcated polity where governance is distributed both in legislative and executive terms at different levels between the center, between the states, between units within a state also. So that these characteristics of federalism are prevalent even in relation to union territory. In fact, I would think that even say the panchayats, the municipal corporations, which now come in by virtue of a constitutional amendment, they are reflective of the need for local governance. You see,
decentralization of power.
Decentralization of power.
Look, I'm not pitching my case. I make it very clear that there is complete absence of principle of federalism between union and union territory. But I'm saying the way majority considers that it is akin to the federalism between full-fledged states and union may not be a correct view.
All right.
In union territory, it would be a hybrid kind of a federalism where decentralization of power, there is no, what are the fundamentals of federalism? The federal unit is not dependent upon the federating unit, namely the state, etc., is not dependent upon its source of power to the union. Constitution is the source of power. So federalism would apply, but the nature of federalism, the threshold, etc., would be different than that of a state. That's what I'm not pitching it to an unrealistically high level.
Yes.
So you're willing to state that the boundaries will be hemmed in, but there will be boundaries where the center will keep its hands off.
Look, I would not put it, yes, I bow down to what has fallen from your right. But in case of union territories having legislature, there would be a federalism. Look, there are union territories, no legislature. We directly control. There is no elected government. So there is no question of there being any federalism. But in Puducherry and Delhi, there is a legislative assembly. The concept of federalism, as my lord, the Chief Justice of India, rightly says, my lord, would apply. But the threshold, as your lord ladyship rightly puts it, boundaries would differ. It would not be all-encompassing federalism. In any case, my lord, India is otherwise also never a complete federal or complete unitary. It's quasi-federal, quasi-unitary. Some provisions are complete unitary, some provisions are completely federal in nature, my lord. So we have chosen that model.
Yes. So let's go ahead.
My lord, your lordships have referred to it, my lord, the Chief Justice, as centralizing trade. So that I made myself clear. I'm not putting it.
All right. Let's see para 10 onwards.
Having given clear-cut demarcation among the units of governance within the country and keeping in mind an undisputed position that Delhi is the union territory. Lord NDMC 9-judge judgment and your lordship's constitution bench judgment. That it is union territory.
Yes.
And is a completely separate unit of governance, distinct and different from the union and the state. It is required to be pointed out that the provisions of services, this is very, very crucial. This is the heart of the matter. It is required to be pointed out that the provisions of services are made in chapter 14 of the Constitution having the title Services under the Union and the States. It does not categorically mention union territories. There is a deliberate silence, which will become clear, further, that it's not just a coincidence that it is not included. There is a conscious omission. The Constitution, which is fully aware of 3 units of governance, that is union, the state and the union territory, categorically excludes the union territory from the said chapter under the heading services under the union and the states. In other words, there are only two categories of services contemplated under union services or posts in connection with affairs of the union. But in connection with the affairs of the union is the phrase I have borrowed from Article 309 itself. And two, state services or posts in connection with affairs of any state. There is no contemplation of any separate and independent services for union territories, since any union territory, whether with or without legislature, is constitutionally an extension of the union, and not only statutes but the constitution recognizes the above position as stated above. All India services officers selected by UPSC or a board controlled by the central government are deployed in connection with the affairs of the union territory, since such affairs are necessarily in connections with the affairs of the union. The inevitable conclusion in chapter 14 under the heading services under the union and the state is that it does not apply to union territory, which becomes clear from Article 308 contained in part 14 itself. Not the first article, and this is again not clinching in my respectful submission. At this juncture, it is relevant to note, and you may not note this, this is very relevant. At this juncture, it is relevant to note that Article 308 of the Constitution was in existence even prior to the insertion of the concept of union territory, which came to be amended by 7th Amendment. Union territory came in 7th Amendment, but 308 was there, by which the concept of union territory is also introduced in Part 8 of the Constitution, and the concept of an administrator to administer the affairs of union territory was also introduced by very same amendment under Article 239. Though Article 308 came to be amended simultaneously with introduction of union territory and the contemplation of an administrator to administer the same, the Parliament did not incorporate union territory within the meaning of the expression state. Lord, this is the amended provision. Lord, kindly see the title, Part 14, Services under the Union and the State, Chapter 1, Services, Interpretation. In this part, unless the context otherwise requires, the expression state does not include state of Jammu and Kashmir. This is the only amendment. Simultaneously, this is a part of 7th Amendment. The Parliament could have said state would include union territories, because elsewhere in other provisions, Parliament has said in the 7th Amendment itself that the word state here would include union territory. Parliament doesn't say in the chapter of service. And please bear one factor in mind. Thereafter it comes. Kindly see, what was the earlier provision which was amended. There is an asterisk here. An asterisk, is also quoted. It's not my paraphrasing. Substituted by the Constitution 7th Amendment Act, Section 29 and Schedule 4. Earlier, it was means a state specified in Part A or Part B of the first schedule. So earlier, prior to the 7th Amendment, the position was in this part, unless the context otherwise requires, the expression state means Part A and Part B states. Delhi was not a Part A or Part B states. I'll come to that later on. That is one more clinching indication. Then, 309. Recruitment and conditions of service of persons serving the union or the state. Provided that subject to the provisions of this Constitution, acts of the appropriate legislature may regulate the recruitment and conditions of service of persons appointed to public services and posts. Please note, in connection with affairs of the union or any state. Those who are working with GNCT Delhi are working for the affairs of the union. Because for this chapter, there is no union territory. Provided that it shall be competent for the President or such person as he may direct in case of services and posts in connection with the affairs of the union, and for the governor of a state. So two things here. or such person as may direct in case of services and posts in connection with affairs of the state to make rules regulating the recruitment and conditions of service of the persons appointed to such services and posts until provision, etc. There are two things. By this very amendment, there is an asterisk. The word governor came to be introduced. That is Seventh Amendment. Seventh Amendment also stipulates administrator for union territory. It does not say governor or administrator. Yes. Second, there is second asterisk. Earlier, prior to Seventh Amendment, it used to say Raj Pramukh. Now, Raj Pramukh in Seventh Amendment is substituted or amended with the word governor. Kindly bear these two facts in mind. Administrator who comes by this very amendment is not included, and Raj Pramukh becomes governor. There is a significance. Para 15. Firstly, not only the recruitment with respect to the person serving in connection with the affairs of the union is exclusively left to the parliament under entry 7 list 1, but their conditions of service is also left to the. There is an occupied field. Those who are serving in the affairs of the union are appointed by the law made under entry 7 list 1. Now, but it cannot be disputed that the term condition of service includes within it posting, transfer, promotion, departmental action, etc. Secondly, there is one unimpeachable indication that the term union territory is kept outside the purview of 309. It is important to note that Article 309 confers the power to legislate an appropriate law and or make rules governing condition of service of persons appointed for the public services and posts in connection with affairs of the union or any state. This makes it clear that entry 41 list 2 can never be made available to union territory as persons appointed in connection with affairs of the union territory are necessarily appointed in connection with the affairs of the union, and the field is occupied by either legislative enactment or any it should be or stroke and I'll change and rules made thereunder, namely under entry 70 list 1, which reads as under the entry under which present regime functions for UT, Union Public Service Commissions, All India Services, and Union Public Service Commission. But all India services, I'll be able to show that from the statutory regime. It is submitted that at this juncture, and elaborated later that there are 3 tiers of services in NCT of Delhi occupied by public servants appointed in connection with the affairs of the union. All India service officers who are governed by All India Services Act 1951, which is undisputably made in exercise of powers under entry 70 list 1. Then DENIC's employees who are appointed and who are governed by DENIC rules, which are made by the President of India in exercise of rule-making power conferred under proviso to Article 309 of the Constitution. And C, subordinate public servants appointed under DAS rules 2022, which rules are also made in exercise of powers under the proviso to Article 309 of the Constitution, clearly indicating that they are working in the affairs of the union. Since the field is already occupied by the legislation made under Article 70 list 1 and rules framed under the proviso to Article 309 of the Constitution, and the chapter of services does not contemplate separate services for covering union territories, the question of examining as to whether entry 41 list 2 would apply to union territory of Delhi or not may not be necessary unless it is established that Delhi is a state. Delhi is undisputably not a state. A, NDMC, B is relevant. Constitution's 7th Amendment Act, which introduced the concept of union territory, made a very significant amendment in the proviso to Article 309 by omitting the word or Raj Pramukh and not introducing the word union territory. To appreciate this, the following hierarchy of units of governance in India existing at the time of 7th Amendment needs to be understood. There were 4 categories of states, namely Part A, B, C and D, which were having governors for Part A states, Raj Pramukh for Part B states, and chief commissioners for Part C and D states. When 7th Amendment came, there cannot be and there is no dispute that Delhi was a Part C state having a chief commissioner, which became administratable now after 7th Amendment and the Union Territory. Now kindly see the proviso to Article 309. Instead of Raj Pramukh, that is Part B state goes, the constitutional amendment says governor, meaning thereby it applies only to Part A states, which are all full-fledged states. The word administrator is conspicuously absent, which was applicable to Part C and D states. They become union territories or some of them merged with other states. The Parliament, while amending the Constitution by 7th Constitutional Amendment, not only not include union territory while defining the expression state under Article 308 of the Constitution and not include administrator in the proviso to 309, but even omitted the reference to Raj Pramukh in proviso to Article 309 and thereby excluded even Part B state from the purview of Part 14, that is services. This inevitably reflects that Parliament very consciously omitted any separate service for Union territory from Part 14, it should be 4 Part 14, under the heading of services under the Union and the states, but even Part B states under the Raj Pramukhs were also kept out of Part 14. So only Part 1, Part A states having governors even before that, big full-fledged states. Now, A and B were merged. They became full-fledged states after the 7th Amendment. So that goes. But another indication. Chapter 2 contained in Part 14 relating to services provides for Public Service Commission, which reads as under 315. But same chapter, services, which reads as under. Subject to the provisions of this article, there shall be a Public Service Commission for the Union and a Public Service Commission for each state. Your Lordships can skip, come to sub-article 4. The Public Service Commission for the Union, if requested so to do by the governor of a state, may with the approval of President agree to serve all or any of the needs of that state. The state can say that UPSC will select, I don't want to have my own service commission. Small states do it for financial reasons, etc. That we don't want to incur infrastructure expenses, etc. Let UPSC decide our role. But kindly see the asterisk, the words or Raj Pramukh omitted by the 7th Constitutional Amendment. Administrator is not added. So, same amendment introduced the concept of union territory and administrator for it.
Though interestingly, the J&K Reorganization Act incorporates a public service commission for the UTs of Jammu and Kashmir.
I will immediately answer that. I was to come to it later, but since that has occurred to my Lord, the Chief Justice of India. Your Lordship may kindly take the Constitution. There is a clear-cut answer. There is a clear-cut answer. Kindly take Article 239AA. Your Lordship said about 3.
239AA3.
AA, sub-article 3. Subject to the provisions of this Constitution, the Legislative Assembly shall have power to make laws for the whole or any part of National Capital Territory with respect to any of the matters enumerated in the state list or in the concurrent list insofar as any such matter is applicable to union territories. Now, Lord, for the testing the argument, accept my submission hypothetically that services fall within this exception of insofar as, and Manoj, specific exclusions. Kindly see B. Nothing in subclause A shall derogate from the powers of Parliament under this Constitution to make laws with respect to any matter for a union territory or any part thereof. So B says that Parliament can, by making law, give powers even to excluded categories to the union territory. I hope, Lord, I am clear. A restricts the power of union territory. One, specific exclusions, 3 in number, and second, implied exclusion if it falls within insofar as such matter is applicable. But Parliament can say that no, we may even give police power to one union territory. That is B. I'll again read. Nothing in
But
subclause A shall derogate.
239A is only applicable to Delhi.
Delhi, not the.
Delhi only.
Kashmir.
You have to.
I'm saying that. I'm saying something else. Nothing in, tomorrow, kindly see,
What 239, this clause 3B says is that in relation to Delhi also, Parliament can legislate even on the state list.
Exactly, I'm saying, that's what precisely I'm saying. Parliament can say that for NCT of Delhi, there would be a separate state public service commission, or there would be, even police will be under the Delhi administration.
So according to you, the Parliament, while enacting the
State Reorganization Act is a parliamentary law.
they can always delegate, they can constitute an institution such as the public service.
Yes. That is number one. Number two, kindly see, my lord, Article 4.
It's the union which constituted.
Which
Yeah,
constitutes
Jammu.
earlier, kindly see, Jammu and Kashmir again is a sui generis, my lord. Example, there was a state, my lord, public service commission. For good reasons, my lord, which are not relevant here, they were bifurcated into 2 union territories. So the Parliament wanted continuance of the Public Service Commission, but leaving it at that, Parliament can, and Parliament did, by law, say that there are no restrictions. You have your own Public Service Commission. That can be done to even Union Territory of Lakshadweep. Parliament can say that you have your own Lakshadweep police service, or your land issue is also given to
Right, but if Parliament is constituting a public service commission for a union territory, which is a power which Parliament exercises, under which entry?
Article 4. Article 4. Article 4, not sub-article 4. Article 4. Kindly see them. Article 4. But first, kindly see 3.
Oh, the question
Formation of
is that the constitution of the service commission in the state of Jammu and Kashmir, if it is in exercise of the parliamentary power, or did the state legislative assembly has exercised that?
parliamentary power. It is
Who is that? If that is the case, then how is that relatable to Article 4? Not relatable to. Sure.
First, kindly see 3.
Yeah.
It is Parliament made state reorganization. First of all, it's not a after UT of JNK, there is no legislative assembly as of now. So the question of assembly making would not arise. Parliament may by law form a new state by separation of territory from any state, or by uniting 2 or more states or part of states, or by uniting any territory to a part of any state, increase the area of any state, diminish the area of any state, alter the boundaries of any state, alter the name of any state, provided that no bill for the purpose shall be introduced in either House of Parliament except on the recommendation of the President and unless where the proposal contained in the bill affects the area, boundaries or name of any of the states, the bill has been referred by the President to the legislature of that state for expressing its
But I'll
views
tell you the
thereon.
problem with this submission. Parliament under entry 70 of list 1 can legislate to constitute a union public service commission. So under entry 70 of list 1, they cannot constitute a public service commission for a union territory. Entry 41 of list 2, according to you, refers to a state public service commission. That will not apply to a union territory.
Which,
That means
unless
that
Parliament
means-
views.
No. Therefore, even Parliament cannot legislate under entry 40 of list 2 to constitute a union territory public service commission. So there is neither a power in Parliament to do that under entry
I'll
70,
answer this in
nor is
detail.
there a power under entry 40 by virtue of your argument which takes away that power, because that is not a power which is relatable. It doesn't apply to a union territory.
Would your lordships, my lord, again see, my lord, para 4, article 4? And my lord, taking taking their argument at its
There may be
best.
still an answer to it.
No, I'll
Which
not
is,
say that.
no, I'll tell you, possibly there's only one way to answer it, and which is to say that though Parliament does not have an express power either under entry 70 or entry 41 of list, entry 70 of L1 or entry 70 of list 2, Parliament will rely upon, the rag bag, as Justice Venkat Chelaya called it, under entry 97. That's the only way to
There are two answers.
break the conundrum.
There are
Parliament
two
cannot
answers.
rely upon anything which is not specifically conferred is vested in Parliament.
Lord, there are two, Lord, answers. Kindly, my lord, read along with me once again Article 4. Any law referred to in Article 2 or 3 shall contain such provisions for the amendment of the first schedule and the fourth schedule as may be necessary to give effect to the provisions of the law, and may also contain any such supplemental, incidental and consequential provisions, including provisions as to representation in Parliament and in legislature of or legislatures of the state or states affected. No such law, no, this is Reorganization Act, shall be deemed to be an amendment of this constitution for the purpose of Article 368.
That
So
will
maybe
not help
Parliament
you.
amended the constitution.
That will not help you, Mr. Surya. A first schedule only deals with the territories of the states. What is the territory? Territorial extent.
No,
Fourth schedule deals with the Council of States.
Leave the territory.
So when
Kindly
it
read
gives
further.
you supplementary powers, that's in relation to the first schedule and the fourth schedule. That will not. Possibly the only way to save this is to say entry 97.
Lord, kindly see that. And there is another answer as well.
Only way we can say entry 97.
Mr. Mehta,
Yes.
see what is pointed out to you. Union powers are under entry 70, list 1. The state powers are under entry 41, list 2.
My lord.
There is no specific, because entry 41 may not be applicable because it is with respect to state. And even as per the Constitution bench judgment also, correct? Union territory is not, it is not a state. So entry 41 may not be applicable so far the Union territory is concerned. But the question which is posed is under which provision of law with respect to the Union territory, correct? The Union Public Service Commission shall be applicable.
State
Look,
public
would your
service.
lordship-
State public service.
State public.
State. My lord, would your lordships come to Article 246?
Because earlier you said that entry 41 shall not be applicable at all because it is not a state. Because it is under Article 239 AA, it is a special power, hybrid power which is given, which is not equivalent to state at all. Therefore, to apply entry 41, correct, will be erroneous.
My lord.
Then under which provision, correct, it will be applicable. That is what you have said, Article 302, 3 services, A, B, C, correct, different, all these things that we have
I'm on
noted.
Jammu Kashmir, my lord. I will kindly see Article 246.
And you get that Act, Jammu and Kashmir Act also.
I'll just.
So that you can have some idea
But I'll,
before making any submission on that, under which provision, under which powers
I'll-
that law is
Lord,
enacted.
I'll definitely, Lord, apply myself to that and Lord, respond. But
Because you will immediately get in exercise the powers under so and so, or in exercise the powers. Immediately you can get from that act.
I'll just not get, but put your lordship, I'll come to it, a little later, I'll apply myself, but please see 246.
That it's covered by 246(4), that Parliament can legislate on any matter on respect of a territory which is not in a state.
And even enumerated in the state list. Can be similar. Parliament has power to make laws with respect to any matter for any part of the territory of India, not included in a state, notwithstanding that such matter is a matter enumerated in the state list.
So is Parliament's legislative powers with respect to union territories.
Yes. So Parliament can exercise the powers under entry 41 list 2 for this territory, because when the reorganization
No,
act,
that will not help you again, because look at the last part of this 240. Notwithstanding that such matter is a matter enumerated in the state list. So even if a matter is in the state list, Parliament can still exercise power on that area for a union territory.
that's what I'm
This is
saying.
not even in the state list according to you.
No.
Whether also the fact that 246 falls under chapter 1 of part 11, which is relationship with
Kindly similar, kindly read it again. Kindly, my lord, read it again.
Mr. Mehta, the answer possibly to my question is that this will only be relatable to entry 97 of list 1. Any matter not enumerated in any other list.
any other matter.
That is, my lord, that can be the answer, my lord. But, my lord, again, my lord,
Yeah.
If you have got,
I'll respond.
if you have got any
reflect on
answer,
it.
subsequently you can
Reflect on it.
clarify and reflect.
My lord, but one.
All right, let's go to
one
para
submission.
25.
My lord, even if my learned friend is right, that would mean that provision in the Jammu Kashmir Reorganization Act may be bad in law. That would not mean that the Delhi would have the legislative power to have.
That you have so said in the earlier, that they have to show under which provision their services are falling within the.
Falling.
Yeah, that is what you have already said.
Yes. But
The only point is your argument that there cannot be a public service commission for union territories may be a very dangerous argument. Because you're conceding ground that look, there can't be a public service commission for a union territory.
unless the parliament permits.
All
Well,
right,
that's
para
the
25.
constitutional.
Let's see para 25.
And my lord, your lordships, Article 315, which provides for commission, UPSC and the State Public Service Commission, my lord, uses the word governor, not administrator. And this amendment comes simultaneously. It could have said governor or administrator as the case may be. This is constitutional silence. A deliberate silence, when I use the word deliberate silence, because both came under the same amendment, 7th amendment. 315 is also amended. Union territory as a concept is inserted, and administrator is defined for the first time by the very same amendment. The amendment made in Article 3154 simultaneously in 7th amendment again inevitably showed that there cannot be any public service commission for any union territory, including Delhi. Having clarified the position that there cannot be any public service commission for union territories, it needs to be pointed out that the function of the Public Service Commission enumerated in Article 323B also makes it further clear that union territory can have nothing to do with appointments, promotions, and transfers. Please see, functions of the Public Service Commissions. Now it talks of both. The Union Public Service Commission or the State Public Service Commission, as the case may be, shall be consulted on the principles to be followed in making appointments to civil services and posts and in making promotions and transfers from one service to another and on the suitability of candidates for such appointments, promotions or transfers. So only union and the state. The position becomes further clear from Article 323, which as reflected above omits the term Raj Pramukh and consciously does not include the term administrator while retaining only governor of the state. Article 323 reads as under. Lord, kindly see sub-article 2. I need not read the whole, my lord. Again, the argument is same. Earlier, it was Raj Pramukh. Though union territory came by this very amendment, administrator came by very amendment, it says governor. Raj Pramukh also deleted. And I have given the hierarchy. Part A, governor. B, Raj Pramukh. C and D, joint commissioner. And Delhi, undisputably, till 7th Amendment, was part C state having a joint commission. Chief commissioner. I stand correct. But now there is another.
I'm not interrupting. I'm just saying, because I need my 90 minutes. The Lordship may have to just overflow. Just because I don't want to interrupt you. I'm just saying something which I don't want to compromise on that.
I'm not repeating anything.
Just something.
Fair. The request is fair.
1 hour is now over.
1 hour is over, but I would request.
I'm not saying
Honorable
I'm just
Bench
pointing
to give me. I'll not repeat anything. These
No,
are.
Raj Pramukh, you are repeating. You said.
Let us come to the next.
And administrative Raj Pramukh, you are repeating.
Yes.
You proceed. Administrative.
Now, Raj Pramukh will not be uttered by me, Lord.
Raj Pramukhs are a relic of the Raj.
Yes.
Gone are those days. Yes.
As your Lordships, my Lord, the Chief Justice of India in one of the matters have said that this is not proposing a girl, that repetition results into any positive result.
I keep on saying that, in the morning when they mention things to you, and constantly, my lord's 10th. No, my lord's 10th. My lord, my client is going to be denied anticipatory bail, 10th. Then you say, no, 12th. No, my lord's 10th. So, you have to sort of break the ice and say, okay, come on.
That's the very apt analogy, my Lord, that repetition doesn't take yes out of the other person. My Lord. Look, another one. Now, completely, my Lord, forget now chapter 14. But I come to another limb of my submission. Another indication that persons working in the union territory are working in the affairs of the union. So now administrative tribunal.
I'm sorry, I'm eating into your time, but there's only one aspect, that is 309 gives power to the union government to regulate all terms and conditions of service of officers who are appointed in connection with the affairs of the union. Could it possibly be that, your argument would be that affairs of the union in Article 309 would mean the entirety of the affairs of the union territory, right? Including all services. The other countervailing argument could be that affairs of the union in Article 309 should include those matters which are entrusted to the union by 239 AA. One way of looking at it is, look, the entirety of the canvas of a union territory of Delhi, notwithstanding 239 AA, is an affair of the union, because the union has jurisdiction on list 1, list 2, and list 3.
Therefore.
But that is subject.
Therefore,
It's a little
Your
tricky.
Lordships have in mind.
309 also subject.
Lord, the Lordships have in mind, Lord, the position, Lord, which is
Takes us to
portrayed. Let me demolish, my Lord, fully crafted perception that we have no power. Let me demolish that. Then your Lordships may examine, my Lord, these legal provisions in that context.
Yes.
But, para 27. The
Yes.
Administrative Tribunal Act is enacted in exercise of the powers under Article 323A of the Constitution. The said article provides that the Parliament may make law constituting tribunals of disputes and complaints with respect to recruitment and conditions of service of persons appointed to public services and posts in connection with the affairs of the Union and another affairs of the state. Now, my lords, may kindly come to section 14 of the Administrative Tribunals. Jurisdiction, powers and authority of Central Administrative Tribunal. Your lordships have, my lord? Page 11. Kindly, my lord, directly come to page 12, the explanation. For those who are acting or functioning in the affairs of the Union, there is a Central Administrative Tribunal. For those who are in the state, there is a State Administrative Tribunal. Page 12, explanation. For the removal of doubts, it is hereby declared that reference to Union in this subsection shall be construed as including reference also to a Union territory. Even their service disputes go before the Central Administrative Tribunal dealing with officers working in the affairs of the Union and not, my lord, anywhere else. That's, my lord, the purpose. Now, my lord, establishment of High Court of Delhi. Bottom of page 12.
Yes.
Page 13. There is yet another clear indication that the Constitution treats Union Territory and UPSC on one hand and the State and State Public Service Commission on the other. Article 241, which is a part of Part 8, that is under the heading Union Territories. It is under this provision that Parliament has made Delhi High Court Act 1966. Article 219, read with Section 4 of the Delhi High Court Act, replaces the word governor with lieutenant governor. Wherever the Parliament wanted, the Parliament has made a provision for governor and lieutenant governor. Please see, my lord. Similarly, Article 230 and 231 also replaces the word governor with administrator. Pertinently, however, parliamentary law of Delhi High Court Act and above quoted constitutional provisions makes it clear that in case of union territories, the service commission is only UPSC and none else. Article 241 of the Constitution, Section 4 of the Delhi High Court Act, and Article 219 and 230 and 231 of the Constitution are quoted above. 230, your lordships can not skip. Kindly see 232B. This is for Delhi. Having a union territory, and please see B, 2B. The reference in Article 227 to the governor shall, in relation to any rules, forms, or tables for subordinate courts in that territory, be construed as a reference to the president. But again, though it's union territory, the reference in Article 227 of the governor to the governor shall, in relation to any rules, forms, or tables for subordinate courts in that territory, be construed as a reference to the president. Then your Lordship, my Lord, kindly see 231, establishment of a common high court for two or more states. This is not for Delhi or any state, but this general provision contained in Part 8. Kindly see the proviso which I have underlined. Provided that if such principal seat is a union territory, there can be a common, my Lord, high court for a state and a union territory. Provided that if such principal seat is in a union territory, the references in Article 219 and 229 to the Governor, Public Service Commission, Legislature, and Consolidated Fund of the State shall be construed respectively as reference to the President, Union Public Service Commission, Parliament, and Consolidated Fund of India. Even if the High Court is a joint High Court for state and union territory, merely because the principal seat is in UT, not Governor, the President, not State Public Service Commission, UPSC, not State Consolidated Fund of the State, Consolidated Fund of the India. Look, there is a threat that there is UT, we don't recognize UT except the powers which are constitutionally ceded, like 239AA.
Yes.
Now, my Lord, kindly directly come to page 15. And this is, my Lord, the heart of the matter, which which would be troubling your Lordship's conscience also, because a very well orchestrated perception is that we don't have any power. What do we do? My learned friend argued that we don't have steering wheel, we don't have gears in our hands, we don't have brake, we don't have clutch. Now kindly see, my Lord, in that context, and I'll answer, my Lord, that question. At the outset, my Lord, para 39, and this is, my Lord, kindly see, my Lord, there are two types of control. My Lord, what the central government is claiming is control for recruitment, appointment, and posting. Nothing else. Rest governance is with the elected wing. And I'll show that. Kindly see. At the outset, it will be pointed out that there is a clear distinction of legislative powers and consequent administrative powers with regard to Union of India and NCT of Delhi. They are functional control and administrative control. Functional control means right to have steering wheel, right to have gears, right to have brake, right to have clutch under their control. So far as the functional control is concerned, it signifies the control of an elected body in its functioning through the officers and employees working in the affairs of the union. That is, day-to-day functioning under the administrative control and supervision of the minister of the concerned department, the Honorable Chief Minister, and the Council of Ministers, that is elected wing. Lord, as my Lord, the Chief Justice of India, Lord, suggested, even in those cases where it is the central end, suppose under 239AA, they are entitled, they can function. The officers will be answerable to the minister, the Honorable Chief Minister, and the Council of Ministers, not to anybody else. Please see. So far as the administrative control is concerned, it would signify the decision as to whom to be posted in affairs of the NCT of Delhi, in which position and post such officers or employees would be posted, transfers to be effected, and disciplinary action to be taken. This control is absolutely necessary since Delhi is the capital and the central control is not only desirable but constitutionally permitted without in any way interfering with the absolute functional control of the elected wing. In case of NCT of Delhi, as explained hereunder in detail, the functional control vests in the elected wing and all officers, employees are required to function under the administrative control and supervision of the elected wing and implementing the programs and policies of the elected wing, which would reflect the wish and will of the electorate, while the administrative control is vested both constitutionally and other in the president and under the order of the president. Kindly allow me to mail. who exercises the same through the Lieutenant Governor. So far as the control is concerned, almost a fiction is created by way of a public perception that they have absolutely no control of the elected government over the officers and employees working in GNCPD. This fictional perception and far from truth, which will become evident from the following paragraphs. Lord, kindly see, in conformity, Lord, your lordships can skip 44, Lord, I'm not taking your lordship's time. Crucial is 45 onwards.
Mr. Mehta, to be on absolute lighter side, nothing to do. When you said that functional powers and the administrative powers and the driving seat, correct, clutch, everything visit them. But according to them, correct, the direction, like GPS, correct, the direction where to go, left side, it is with the central government.
Lord, after reading, Lord,
That is what, this is distinction between the administrative power and the functional power.
No.
Correct.
I'll, my Lord, respect.
Suppose according to them, if they want to go straight, they cannot go because of the administrative power, because the direction will be go right side or left side.
Lord, after going through this,
Absolute lighter, nothing.
I know. Lord. Sometimes it's good, my Lord, to have lighter moments. Lord, after going through this, I can say this, my Lord, in this very simile, Dr. Singhvi said, they have the steering wheel, they have the gears, they have the clutch, they have the brake, they decide the direction also. Only the make of tires, whether MRF or CH, is done by the LG. And if still you cannot drive, then there is something seriously wrong with your driving ability, not with selection of tires.
But you know, Mr. Mehta, actually, see, as we know in the States, for instance, the most important part is where do you post an officer, right? Whether an officer will be in Secretary Finance, Secretary Home, Secretary Education, Secretary Environment, Secretary Youth Affairs or Sports,
Etc.
So what you are saying is that, look, we will post you as Secretary Finance. Once you are posted as Secretary Finance, you will act under the jurisdiction of the Minister of Finance. We will post you as Secretary Education. Then you will be reportable to. You will report only to the Secretary, to the Minister for Education and the Delhi government. But suppose they find that somebody is not really up to, not functioning as effectively as in that particular role. Your contentions, of course, Dr. Singhvi also conceded that we are not disciplinary jurisdiction. But they cannot even switch officers.
They can. I'll answer your lordship's question. And my lord, kindly park that question till your lordship goes through this. I'm saying this with a sense of responsibility. They can always say that this man is not fit for the health ministry, post it in industries ministry. They have to send a letter through LG to the MHA, and it is never refused.
That's a matter of, that's a matter of accommodation in practice.
Kindly, my lord,
Otherwise, look at it from
that
this
question.
way.
Kindly park.
An officer knows that, well, I cannot be moved out from this position at all. I cannot be moved out as an excise commissioner, however I do, unless I have a green signal from MHA.
Kindly, my lord, kindly park that.
Whatever I do as an excise commissioner, whatever I do as a Secretary Education,
unfortunately,
unless I have the green signal, I will never be moved out.
Unfortunately,
will that not dilute even the functional control? That's the point. Yes, recruitment, disciplinary control. You're right, absolutely. Dr. Singhvi, in fact, didn't go as far as that when he made a very nuanced.
I hope, my lord, these are tentative observations.
Question is about posting. You see that?
Lord, sometimes a wrong perception repeated and carefully orchestrated through various mediums, Lord, have the tendency of entering our minds. Lord, the following paragraphs.
All right, quickly, let's read it.
Are devoted to
read para 45.
And my lord, why this is relevant and why your lordship may park that, my lord, apprehension, tentative apprehension, till your lordship, my lord, goes through.
All right, let's quickly read that para 40.
First, all India service officers, Denic officers, and all other officers working for GNCTD are under the functional control of minister concerned the Honorable Chief Minister and GNCTD and Council of Ministers as pointed out hereunder. Secondly, for any officer, the most important element of his service is career progression in terms of promotion, which is based upon the annual performance appraisal report. Please don't make any conclusion till I take your lordship through this fully. Any adverse entry in APA, that is annual performance appraisal, is capable of spoiling his chances of promotion and his future career progression. So far as all senior and middle level officers are concerned, who are under the functional control of the elected government and through whom the will and wish of the electorate in terms of the programs and policies of the governments are to be implemented, their APAR are under direction, control of the Honorable Chief Minister of Delhi, either as reporting authority, reviewing authority, or accepting authority. In other words, depending upon the functions of each senior level and middle level officers under the supervision and control of the ministers of each department, which includes right from secretary, chief secretary, etc., right from secretary downwards. The Honorable Chief Minister can give suitable grades which will have a direct bearing on his future career progression. APAR consists of annual work plan to be decided twice a year. Now, this answers your lordship's question. That is, once at the start of the financial year and secondly by way of a mid-year review. The assessment of officers in APAR is done on following attributes. This the elected wing does. Assessment of work output. The lordship would have said efficiency. This man should be efficient in this field and not in that field. Kindly see, it consists of following sub-attributes. Accomplishment of planned work, quality of output, accomplishment of exceptional work or unforeseen task performance. Then second, the 30% weighted, assessment of personal attributes. It consists of following sub-attributes: attitude to work, sense of responsibility, overall bearing and personality, emotional stability, communication skills, moral courage and willingness to take a professional stand, leadership qualities, captaincy to work in time limit, capacity to work in time limit. Then third, 30%, assessment of functional competency. It consists of following sub-attributes: knowledge of laws, rules, procedures, IT skills, and awareness of local norms in the relevant area. Strategic planning ability, decision-making ability, initiative, coordination ability, ability to motivate and develop subordinates or work in a team. All these attributes are decided and gradation is given by the Honorable Chief Minister. Kindly report further. It is submitted that Honorable CM appraised the performance of officers of GNCTD through the mechanism of APAR, wherein the performance of officers of the GNCTD is evaluated by the CM, i.e. elected government, on a scale of 0, that is worst, to 10, best. And also a pen picture on conduct of these officers are recorded in writing by the Honorable CM in these APARs. I, as an officer, cannot say that I owe my allegiance to MHA. I will not take orders from you because he is the one who is writing my annual performance appraisal reports. In the last 3 years, that is 2019-20, 2021, 21-22, the Honorable CM had appreciated the work of all IAS officers, principal secretaries, secretaries and heads of the department working in GNCTD and accorded them outstanding rating. Grading from 8 and above is outstanding, not out of 10. To all officers except one officer wherein very good grading was given to such officer for the year 2019 to 20. Even this officer has been graded as an outstanding officer for the year 2021 and 21-22 by the Honorable CM. Details of Honorable CM. Details of which are mentioned in a, kindly come to page 43. For my satisfaction, please come to page 43. But if I am not working satisfactorily, if I am not fit for that particular post, if I am not listening to the ministers, if I am not discharging my functions properly, if I say that I owe my allegiance somewhere else, then it directly reflects on my APR, which is not to be written by the central government or even by the LG. Kindly see page 43. I will not read everything, just have a glance. Mr. So-and-so, ACS power, grading 10 out of 10. so-and-so, ACS, UD and director, local bodies, 10 out of 10, then 9, 9.5, 8, 9.50, 9.80, 8.50, etc., etc. Not everyone. Kindly come to 45. Look, this is the next year, 2021. These are the people working under their supervision, under their control, under their administration, discharging the duties given by them, and they judge them. Lord, please see 9, 9.5, 9.5, 8.
Between Mullah's pleadings and written submissions seems to have been obliterated. My learned friend's repeated saying about not going into facts seems to be obliterated.
No, this is a
Written submissions are having facts, no pleadings, and your lordship is to be drawn in, whether in a lighter vein, not so light vein. Whereas our allegation is central government is trying to swallow our powers. What is happening today is my entire morning time is going to be swallowed by my learned.
My Lord, I would, my Lord, give one full, many credits to Dr. Singhvi, but today, right now, one credit, he interjected at a right time from his point of view. This was the time where he should have interjected and derailed the argument. I refuse to be derailed.
So, Solicitor, I remember one day when Dr. Singhvi, with his characteristic flourish, came in the morning for mentioning matters before Justice Narasimha and me and said, I'm filing an affidavit. Please ask the solicitor.
Your lordship refused.
We refused that. We said, we're not going to go into
And
it.
repeatedly he's protesting that I will not do it.
All right, but we are not going to be impacted by it. He just sort of said that
That's all right.
individual
This also is taken.
individual gradings.
They can refuse that this is a false figure.
But Mr. Solicitor, we got your basic. We'll look at it at a doctrinal level that the APARs are written by the Chief Minister. You may make that limited point. Let's not go into
Kindly, my Lord, come to page.
Anyway, you want to point out
because then
that
you
the
have a whole
apprehension,
lot of material rejoined at the
yeah,
shoulder.
your submission is that apprehension is not well founded, correct? That though officers are not properly working, correct, nothing can be done. That is what your submission.
Yes, I'm respectful. I'm
Because
grateful.
ultimately you say
And another
submission is done by the Chief Minister.
Nothing inconvenient will come.
No difficulty.
You can sit.
I'm saying nothing. I'm just.
No, you
hearing.
rightly
You're the one who's
got up.
speaking.
Lord, another thing. Lord, I'm answering your lordship's apprehension that what if the person is not fit for that job? Then, my Lord, kindly see page 47. This is not facts. This is a format, standard format. Standard format. What is the matter in which, my Lord, what are the issues on which he is to be judged by the...
in the APRs, right? Annual performance. All right, now let's go on to the next point, Mr. All right, we'll now go on to para.
This job,
We've
etc., etc. Not competent.
Now let's read para 59. That's the next point. I think this point we have covered now.
Yes.
Para 59, Constitutional and Statutory Scheme Governing Services. This is what you were showing us last time when we closed on Thursday.
Yes.
Let's look at that now.
But your lordships have, my Lord, kindly, my Lord, now come. My Lord, your lordships have still in mind that what will they do if you don't have any control? So therefore, just to show that the steering, clutch, gear, brake, direction is theirs.
All right, we'll see whether what they have and what.
There is something, my Lord,
Anyway,
seriously wrong if they say we can't function.
Para 59, let's get on.
Yes.
Para 59 now.
Lord, 1 year of
What you can do, solicitor, is you have already divided into subheadings. Take each of us, we will go through each of them. You tell us broadly the gist of what you are saying and you can make your argument on that in each of those from 59 onwards. Para
51, your lordship.
59 is the constitutional scheme that you are talking
No,
about.
no, Lord, 51, my Lord, if your lordship.
Okay.
How, Lord, the president has made, my Lord, the transaction of business rules. How the officers will work.
All right. That
That
according
is
to
a
the
direct bearing, my
that
Lord, on
TBR shows that they work actually under the minister concerned.
concern, my Lord. And he judges their competence, ability, leadership quality, sincerity, etc., etc. My Lord, there are several attributes. The council shall be collectively responsible for all the execution orders issued by any department in the name of Lieutenant Governor and contracts made in the name of the President in connection with the administration of the capital, whether such orders or contracts are authorized or not. And 2, without prejudice to the provisions of Sub-Rule 1, the minister in charge of the department shall be primarily responsible for disposal of business pertaining to that power. You have the power to do. 14. the decision of council relating to each proposal shall be separately recorded and after approval by the chief minister or the minister presiding shall be placed with the record of the proposal. After approval of the chief minister or the minister presiding, the decision of the council as approved shall be forwarded to the by the secretary to the council to the lieutenant governor. My lord, that is for sub-article 4. Differ and refer. 2. My lord, I am giving facts, my lord, because I have chosen not to give facts through media. The media carried an article that out of 7, I'm sorry, my lord, kindly, I'm making this with a sense of responsibility.
Yes.
That out of 7 difference, 5 are in this regime. My lord, I am ready to place before your lordships what were the differences.
7 difference.
Which
Lord, I said that from,
Oh, okay.
which I refer to the president.
my lord, that right from, my lord, 2012 till date, 18,000 files came for differ and refer power. 18,000 file clear, nothing, my lord, it's just, my lord, files. Only 7 times the LG differ, 12 till date. 5 times, according to them, during this regime. That is true. That's a fact. They could not bring it by way of an affidavit. It came by way of a news item, which I avoided doing. But if your lordship wants to be satisfied that intervention, differing and reference to precedent was a mandate, I am ready to place the files before your lordship. So thereby the file goes to the LG for that power of differ and refer, not for anything. Where a proposal has been approved by the council and approved, record of the decision has been communicated to the LG, the minister concerned shall take necessary action to give effect to the decision. That again minister will take that and direct the secretaries and his staff. If the department concerned are not in agreement regarding such a proposal, the minister in charge of any of the department may, if he wishes to proceed with the proposal, direct that the proposal be submitted to chief minister for order or direction or for laying it before the council. There are internal disputes, there can be 2 ministries involved, there may be difference of views. Then it goes to the honorable chief minister and if necessary to the council. 15. Except as otherwise provided by or under these rules, proposals or matters may be disposed of by or under the authority of the minister in charge, who may, by means of standing orders, give such directions as he thinks fit for the disposal of proposals or matters in his department. Copies of such standing orders shall be forwarded to the LG and the chief minister, provided that such standing orders shall not relate to the statutory powers conferred under any law upon the officials. There are some revisional powers, etc., given to the secretaries under various laws. Obviously, there can be standing orders that are quasi-judicial powers. Then 16, minister shall by means of standing orders arrange with the secretary of the department what matters or classes of matters are to be brought to his personal notice. Your lordship knows, my lord, entire nation, all files do not go to the ministers, whether it's union, state or union territory. But minister can say that these files will have to be given to me for my personal. Otherwise, it is rooted within the administrative, bureaucratic hierarchy. Copies of such standing orders shall be forwarded to the LG and the chief minister. Every Monday, or if it is a holiday on the next working day, the secretary shall submit to the minister in charge a statement showing the particulars of important proposals or matters disposed of in the department by the minister and the secretary and other officers during the preceding week. A copy of the said statement shall be simultaneously submitted to the lieutenant governor and the chief minister. Thus, the functional control for undertaking the governmental business lies absolutely with the minister concerned, and for this purpose, concerned IAS officers and all other officers report to the minister concerned. Lieutenant governor has no role except constitutionally provided under Article 239 AA4. Differ and refer. In case of IAS officers does not follow the provisions of TOBR, then he is liable for disciplinary action for violation of provisions of Rule 3 of All India Service Conduct Rules. You immediately bring it to the notice of the MHA. This is what it is to happen. That's the scheme. That's the scheme of the Constitution and scheme of the rules, service rules, that this man is not behaving properly with me. You take departmental action. Then 53. it is submitted that if any minister concerned finds that an IAS officer or any other officer is violating provisions of TOBR or any conduct rules, he may report it to the disciplinary authority, that is MHA, through Lieutenant Governor, as undisputably the disciplinary authority is MHA. While the appellant is making claims using hypothetical situations that the elected government would not be able to implement its policy without having control over transfer and posting of the officers, the above mentioned TBR, my lord, 55, your lordships can, my lord, ignore, kindly come to 56. So there is one more check. 56. My lord, kindly bear with me, my lord, this is not a matter where, my lord, your lordships are deciding about the capital of the nation, my lord. So I would be failing in my duty, my lord, if I curtail something which I think it to be relevant and appropriate for your lordship's assistance.
No, that is why, Mr. Mehta, we are hearing you and listening you.
No, your lordship. I'm grateful.
Otherwise, despite your 1 hour has already gone, we are just listening because very important matter is there. Therefore,
I'm grateful.
but still you have to consider that
And
time
according-
constraint.
I'm skipping what is not relevant or what is repetition. I'm skipping. It is most respectfully submitted that apart from the above referred legal position showing services falling within the domain of Lieutenant Governor, the Honorable Supreme Court, with its judgment dated so-and-so and writ petition so-and-so as directed, constitution of a civil service board consisting of Chief Secretary and other high-ranking officers. In case of Delhi, CSP consists of Chief Secretary, the second senior most IAS officer in GNCTD, and Secretary Services, not again GNCTD. GNCTD to guide and advise with regard to transfers and posting, etc., to the Lieutenant Governor. The Lieutenant Governor decides the transfers and postings of all India service officers on the basis of recommendations made by the CSP. Lord, I have annexed the copy. The following framework ensures check and balances in the system to administer the capital wherein disciplinary control lies with the MHA, transfer and postings lies with Lieutenant Governor, and functional control lies with the. Look, this is the harmonious balance with the Constitution and the service rules have provided for. And it is operating since 1992, which now my learned friend wants to change without showing under which authority of the Constitution he has the power. Now, my lord, kindly see, kindly come to, my lord, 62. The above referred three categories of central services are the categories for the entire country. So far as Delhi is concerned, its administrative setup is as per the following hierarchy. So, Chief Secretary, then Additional Chief Secretary or Principal Secretaries and Secretaries, then DENIC officers and DAS officers. So, this is the broad administrative hierarchy. Now, kindly see, the provision. So, this is again the heart of the matter. How the central government constitutionally and as per statute, empowered for recruitment, posting, transfers, etc. Lord, your lordships have seen 239(1). Article 239(1). Lord, I am not reading it. Please read, Lord, Rule 46 of Transaction of Business Rules, Lord, framed by the Honorable President. Lord, there are blanks, Lord, para, I will fill it. Lord, it's there already in the Lord paper book. With respect to persons serving in connection with the administration of NCT, the Lieutenant Governor shall exercise such powers and perform such functions as may be entrusted to him under the provisions of the rules and orders regulating the conditions of service of such persons or by any other order of the President in consultation with the Chief Minister, if it is so provided under any order issued by the President under Article 239 of the Constitution. My Lord, kindly mark one thing. There is a provision made by the President which empowers the Lieutenant Governor with regard to transfer postings, etc. And if there is any provision which requires him to consult the Honorable Chief Minister, he will consult the Honorable Chief Minister. But bear one fact in mind, there is one direction or order of the President in the form of TOBR, because something would turn when I show the scheme of the GNCTD. Notwithstanding anything contained in Sub-Rule 1, the Lieutenant Governor shall consult the UPSC on all matters on which the Commission is required to be consulted under clause 3 of Article 320. And in every such case, he shall not make any order otherwise than in accordance with the advice.
We'll take a Just take a comfort break for 5 minutes. We'll be back in 5 minutes.
Please. Sir.
Both.
Yes, sir. Your lordships have both the control. There is no dispute.
Mr. Solicitor, this was not time out for you, huh? So this is included in your time.
Now, few pages, but they are very, very relevant.
All right.
And would answer your Lordship's query.
Now that next part you can read now.
Yes, sir. Lord, your Lordships have seen Rule 46
Yes.
empowers the LG to act as per his discretion. Lord, if President provides consultation, with consultation, otherwise without consultation. Lord, now kindly see Rule 57 of these very rules made by the President at page 24. The Chief Secretary and the Secretary of the Department concerned are severally responsible for the careful observance of these rules, and when either of them considers that there has been any material, instead of giving effect to such departure, he shall personally bring it to the notice of Minister in charge, Chief Minister, and the Lieutenant Governor. There is a mandate that this functional autonomy of the elected wing will have to be complied with. If there is any deviation by anyone, he is personally responsible to bring it to the notice. Now, my lords, may kindly see, my lord, under Article 239AA 7, lord, please see, my lord, for a second, 239AA 7. There is an act made, my lord, and I am relying upon 2-3 provisions of that act, which I have not, my lord, argued earlier. 239AA, sub-article 7. Lordship has the foregoing clauses and for all matters incidental or consequential thereto, and B, any such law as is referred to in subclause A shall not be deemed to be an amendment of this Constitution for the purposes of Article 3 standing that it contains any provision which amends or has the effect of amending this Constitution.
It's like the Article 4, similar to Article 4.
Yes, my lord, but even 239AA can be, my lord, varied or changed or modified in exercise of this power. Lord, it's an extraordinary power because it's in union territory. Otherwise, my lord, as I have said, such wide powers are not found anywhere in the Constitution. Now, in exercise of this power, my lord, the GNCTD Act is enacted by the Parliament. And please see Section 41 of the GNCTD Act.
That is at page.
Yes, my lord, when Dr. Singhvi read this,
20.
he read only 2 and missed 1. And your lordship would realize why, from his point of view, my lord, the right thing. Matters in which Lieutenant Governor to act in his discretion. The Lieutenant Governor shall act in his discretion in a matter, 1, which falls outside the purview of the powers conferred on the Legislative Assembly, but in respect of which powers or functions are entrusted or delegated to him by the President. But I am linking this with Rule 46, a direction of the President which empowers him to act as per his own discretion and not as per the aid and advice of the Council of Ministers. And here,
No, but 46 also says he will exercise such powers and perform such functions as may be entrusted to him under the provisions of the rules. And under the provisions of the rules and orders regulating the conditions of service of such persons. So if the Article 309 rule gives powers to the LG, then he can exercise those powers.
I bow down. The rules are coming further. Now, please see 49. Relation of Lieutenant Governor and his ministers to President. Notwithstanding anything in this Act, the Lieutenant Governor and his Council of Ministers shall be under the general control of and comply with such particular directions, if any, as may from time to time be given by the President. And my lord, my crucial submission for your lordship's consideration is that the notification dated 21st of May 2015, that services will be Lieutenant Governor's discretion, is direction of the President in exercise of this power, read with Rule 46. The notification dated 21st May is in fact and in substance the delegation of power by the Honorable President in exercise of the powers under Article 239. Lord, Article 239, my Lord, kindly do not forget Article 239, which says the President shall administer union territory, either himself or through administrator. So that is first power of delegation. This is, my Lord, that delegation. Read with Section 41 and 49 of the GNCTD Act. My Lord, it was read before your Lordships and it gives an impression as if there is an amendment made. Your Lordships would not go by the language used or your Lordship would examine the substance of the notification, not the form. The form, the direction says, contemplated under Article 312, it is submitted that the recruitment to Group A services is made by UPSC. My Lord, I may skip that. Your Lordship knows, my Lord, the UPSC conducts exam for various services. Marks are given, IAS, IPS, IFS, IRS, economic services, etc., etc. My Lord, that I can skip, my Lord. Kindly, my Lord, now come to para 70. Para 71, I'm sorry, para 71. The Group A, All India Services, is central services get their respective cadre under the All India Services Act, read with All India Services Cadre Rules, 1954. It's already there on record, but the relevant part, which is relevant, I have already quoted. So far as the states are concerned, not the union territories, the officers of All India Services are allotted qua each state. Lord, your Lordship knows their cadre is determined. If I am selected in IAS, I can choose Gujarat as a cadre if my marks so permits, or if my marks do not permit me, I will get any cadre which is left over. So far as union territories are concerned, which are, this may kindly be examined irrespective of the time constraint, because this would be the heart of the matter, my Lord. Again, this matter has more than one heart, my Lord. I repeated it thrice, therefore, my Lord, this is the third heart of the matter, my Lord. My apologies to your Lordship. So far as UTs are concerned, which are directly controlled by the Union of India and not by any state, the officers get the cadre allotted, which is known as Agmut cadre, which consists of the following. Lord, allow me to read because something would turn on. There is a history behind this, Lord, why this kept on changing. Arunachal Pradesh, Goa, Mizoram, Andaman and Nicobar, Chandigarh, Daman and Diu, Dadra and Nagar Haveli, NCT of Delhi, Lakshadweep, Puducherry, Jammu Kashmir and Ladakh. As on date, Lord, these are the Lord, Agmut cadre. The Agmut cadre officers can be posted in any of the above referred segments. I can go to Sikkim, I can go to Arunachal, I can go to wherever. All India services are governed by All India Services Act 1951. Then, my Lord, Section 3, 74, para 74. Section 3 of the 1951 Act, under the title Regulation and Recruitment of Conditions of Services, empowers the central government to make statutory rules regulating recruitment and condition of service of persons appointed to All India Services. The first important rule in All India Services cadre rules, the definition clause are relevant. Lord, please see, my Lord, the definition clause of cadre rules. Cadre officer means a member of Indian Administrative Service. My Lord, the top bracket in GNCTD, heads of the department. Cadre post means any of the posts specified under item 1 of each cadre in schedule to the Indian Administrative Service fixation of cadre strength regulations. Your Lordships are not concerned.
Yes.
Lord, this is crucial, Lord. There are two definitions. One is state. State means a state specified in the first schedule to the Constitution and includes union territory. D, state government concern in relation to a joint cadre means the joint cadre authority. So there are two expressions, state and state government concern, both separately defined. State means state includes union territory, and state government concern means joint cadre, because I will show what the joint cadre is. The constitution of cadres is provided for in Rule 3, which reads as under: there shall be constituted for each state or group of states an Indian Administrative Service cadre, the cadre so constituted for a state or a group of states is hereinafter referred to as state cadre or, as the case may be, a joint cadre. More than one state. Correct? From the conjoint reading of the aforesaid provision, it becomes clear that there are two concepts, state and state government concerns. Kindly, my lord, come to the next page, 28. So far as postings of all India officers are concerned, there is a specific provision in statutory rules, namely Rule 7, which reads as under, all appointments to the cadre post shall be made in case of a state cadre by the state government. When there is a full-fledged state, I am allocated or I am allotted a Maharashtra cadre, then by the Maharashtra government. B, in case of a joint cadre by the state government concerned, please, my lord, note here and my lord, park it. Rest may not be relevant for your lordship's consideration. I have quoted so that I am not accused of, my lord, selectively quoting. 78. The provision based upon which some confusion is created is a provision contained in Rule 11A, which reads as under, authority to exercise certain powers in respect of members of the service serving in connection with the affairs of the state, constituting a joint cadre. The powers of the state government under the second proviso to sub-rule 2 of Rule 4 under clause so-and-so, 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 and Rule 7. We are concerned with Rule 7, which provides for posting. In relation to members of services serving in connection with the affairs of any constituent states shall be exercised by the government of that state. Correct, my lords? Now please read further. How, my lord, this is to be read harmoniously. Your lordships have, my lord, seen that any definition clause starts with except the context otherwise requires. Unless the context which I am giving is accepted, 7 and 11A would be in contradiction, distinction to each other, which can never be, my lord, the intention. Please, it is submitted that a literal and out of context reading of 11A is capable of creating a confusion that Rule 11A and Rule 7 contained in very same rules are in contradiction to each other. At the outset, it is submitted that the word joint cadre in Rule 11A is in right context used as a joint cadre of two full-fledged states without any union territory. And I'll read it 11A again. In Rule 11A, the word state is not used as defined under Rule 2C, which itself starts with unless the context otherwise requires. Rule 11A applies when there is a joint cadre of more than one full-fledged states. In such a case, the power under Rule 7 would be exercised by the government of each constituent state. But Assam and Meghalaya has a joint cadre. Then Assam will decide Assam officers, Meghalaya will decide Meghalaya officers. And there is a history behind it. Lord, please note, 11A was inserted subsequently after 1972. And that will make it clear that 11A is not in contradiction to 7. It says when two or more full-fledged states create a joint cadre, then 11A will apply. Lord, kindly allow me to show that history, Madam. The provisions of section 11A was introduced on 11 January 72 as a separate state of Meghalaya was to be formed on 21st January 72, separated it from Assam. Just 10 days before the separation. Otherwise, my lord, this cadre was entirely UT cadre. Both divided state of Assam and carved out state of Meghalaya. No, I'm sorry, I stand corrected. Not all were not UT cadres, but my lord, this bifurcation happened. Had joint cadre then and continues to have a joint cadre even now. In other words, Rule 11A is not in conflict with Rule 7, and in both the rules, the term state would mean full-fledged states. When there is a joint cadre with some union territories also included in the joint cadre, the posting would be made by the state government concerned. Lord, 7B, your lordship would recall. As stipulated in 7B, as noticed earlier, the power of posting is vested in state government concerned under Rule 7 of the Indian Administrative Service Cadre Rules. The term state government concern is defined in Rule 2D of the said rules, which means joint cadre authority. Now, kindly pause here for a minute and minutely see, 11A doesn't use the word state government concern. It says by the state, respective state. Therefore, the intention is, in view of the historical background, that when there are two or more full-fledged states having a joint cadre, then the state government concerned will decide. There, state would not include union territory. As noticed earlier, I'm sorry, 85. For this purpose, now, who is, your lordships have seen, state government concern means joint cadre authority. Now, who is the joint cadre authority? For this purpose, it is necessary to go to All India Services Joint Cadre Rules, which are statutory rules. Rule 1-2 reads as under, they shall apply to joint cadre constituted for any group of states other than joint cadre of union territories. Kindly mark this. Something may turn on. Then definitions. In these rules, unless the context otherwise requires, joint cadre authority means the committee of representatives referred to in Rule 4. And constituent states would mean states in respect of which a joint cadre is formed. That is the states. These are the rules made in 72 itself. The lordships would notice this. At this juncture, a little history as to why All India Service Joint Cadre rules were required to be formulated and why they were formulated may be relevant. The joint cadre rules were framed when there was one service for all union territories, that is pre-Agbut era. All union territories were clubbed together before 72. This is the reason why Rule 1-2 excludes joint cadre of union territories. When the joint cadre of only one union territory was in existence, the joint cadre authority was Ministry of Home Affairs for all union territories under the Government of India Allocation of Business Rules 1961, which are made in exercise of powers under Article 77 of the Constitution of India. The relevant part reads as under, my lord. Kindly read, my lord, the highlight, the underlined portion. This is for union territories, then union territory with legislature. There is a detail, my lord, without legislature, with legislature. We are concerned with legislature, and that too NCT. There is a separate provision. These are constitutional rules. I will not read, but I'll cite a judgment that rules made by the president have the statutory force. It's having the force of a statute, not just statutory rules. All matters falling within the purview of the union government in terms of provisions contained in Part 8 of the Constitution, insofar as these are applicable to National Capital Territory of Delhi and the Government National Capital of Delhi Act, excepting matters with respect to entry 18 of the state list, and all such matters as have been specifically assigned under these rules to any other ministry or department of the Government of India. Kindly come to D, page 31. General questions relating to public services in the union territories and service matters insofar as these fall within the purview of the state government relating to officers of Indian Administrative Service and Indian Police Service serving in connection with affairs of the union territories. All service matters under the rules framed by the President under Article 73. Then NCT of Delhi, Andaman and Nicobar Islands, Lakshadweep, Daman and Diu, Dadra and Nagar Haveli services, that is DENIS, and Puducherry Civil and Police Services, etc. This is how these rules have been understood and applied by the Government of India. Right from inception, this is how these rules are applied. The joint cadre authority for all India service officers in cadres having union territories is MH. Now kindly see further. Till the year 1987, the following union territories were having a joint cadre. Lord, kindly read this. Arunachal was a joint cadre, was a UT. Goa was a UT. Mizoram was UT, and rest, even today are UT. Correct? I'm not reading. Out of the aforesaid union territories comprising of union territory cadre, that is post-Agmut era, the following 3 union territories became full-fledged states in the year 1987 itself. That is Arunachal Pradesh, Goa, and Mizoram. As a consequence of 3 out of the 10 union territories having joint cadre becoming states, the central government was required to take a decision about the treatment to be given to this newly emerged joint cadre, as a result of which a separate cadre was reconstituted, which came to be known as Agmut cadre, which consisted of 3 newly become states carved out of the union territories with remaining union territories. So 3 states, it was a hybrid kind of a cadre, 3 states and 7 units, which continues till date with addition of Jammu, Kashmir and Ladakh now. The Joint Cadre Authority, however, continued to be the Ministry of Home Affairs, Government of India. But under the rules made by the President, which I read, it is submitted that prior to the creation of Agmut cadre, all functions of the cadre controlling authority, that is state government concerned, under Rule 2D, referred above, was being exercised by the Joint Cadre Authority, which was constituted with a notification dated 3/4/89, a copy of which is annexed herewith and marked as Annexure D. Lord, if your Lordships can, my Lord, allow me to read that. That's already a part of the record, but it is, my Lord, at. This is the quotation. Yes. 71. Page 17. I'm sorry. This is a part of my earlier document, but I'm just for ready reference so that your Lordship gets it in one document. In exercise of, your Lordship gets 71. In exercise of the powers conferred by subsection 1 of section 3 of the All India Services Act, read with sub-rule 1 of Rule 4 of the All India Services Joint Cadre Rules, the central government, in consultation with government of states concerned, hereby constitute the Joint Cadre Authority for joint IAS, IPS, IFS cadre of Arunachal Pradesh, please mark, my Lord, Goa, Mizoram, and Union Territories as below. This is pre-Agmut. Chief Secretary Arunachal Pradesh, Chief Secretary Goa, Chief Secretary Mizoram, Additional Secretary in the Ministry of Home Affairs in charge of UTS Division, and Joint Secretary UT in the Ministry of Home Affairs. Yes. This was, my Lord, pre-Agmut position. Now kindly, my Lord, come back to page 32. Are your Lordships with me at page 32?
Yes.
92. After the aforesaid change, the Joint Cadre Authority held its meeting in October 1988. The resolution passed and decision taken at page 137, 139 of Convenience Compilation Volume 4. However, for ready reference, the relevant parties reproduce here. The resolution passed is on page so change. So kindly see these minutes, and this will connect the dots. How the Union of India became the Joint Cadre Authority for postings, transfers, etc., etc. Now, that 4-member committee deliberated and passed this resolution. This was a Joint Cadre Authority then. Prior to reorganization of the UT cadre as a new joint cadre of the IAS, IPS known as Agmut cadre, all functions of the cadre authority as well as of state, as defined in various rules, regulations governing the terms and conditions of all India services, were being looked after by the Ministry of Home Affairs. However, the attainment of statehood, after attainment of statehood by some of the union territories, and consequently after reorganization of the cadre, the government has notified the constitution of Joint Cadre Authority for the Joint Cadre with a notification dated so and so, which I read, thus bringing the Joint Cadre within the ambit of All India Services Joint Cadre Rules as amended from time to time, in addition to other service rules. In the interest of proper management and smooth functioning of the Joint Cadre within the 4 constituent units of the cadre, namely Arunachal, Goa, Mizoram, and Union Territories, it has become imperative that the joint cadre delegated some of its routine functions to and authorize the Ministry of Home Affairs within the UT division and other constituent units to exercise those functions and powers, though within the policy framework as determined by the Joint Cadre Authority from time to time. JCA has given a serious thought to the above proposal. JCA has pointed out above, in the interest of cadre management, strongly feels that service matters of local nature, which do not have any adverse impact on the overall structure of the services or the cadre as such, should be dealt with by the constituent units at their own level, as it may not be practicable or desirable for the joint cadre authority to go into these matters in detail. Now, my lord, the delegation comes. Functions to remain with MH, UT division. Transfer postings of cadre officers from one segment to another. However, for this purpose, JCA will frame proper guidelines, keeping the overall interest of the service officers as well as the constituent units in view. Till the new guidelines are framed by the JCA, transfer postings from so-and-so will be guided by the guidelines as existing on the day. Then, my lord, kindly, my lord, skip and come to page 93. Para 93, I'm sorry. It is submitted that this is how the Ministry of Home Affairs continues to remain the joint cadre authority. These rules are not under challenge. Cadre rules are not under challenge. Joint cadre rules are not under challenge. No act is under challenge. In the context of the above referred statutory scheme, it is necessarily for the GNCTD to show to this court as to how it is the cadre controlling authority or joint cadre authority which can exercise any powers over All India service officers under Rule 7B of All India cadre rules. But I am showing something which they have not been able to show while asserting a particular constitutional proposition. At this juncture, it is relevant to note that President of India had already delegated. Now, your lordship would have the question, why, how LG comes? Well, this is the answer. At this juncture, it is relevant to note that the President of India had already delegated all powers relating to services of Union territories to the administrator, that is Lieutenant Governor, with a notification dated 59, which is superseded by the notification dated 24th September 1998, which is a part of the record note I have just quoted for ready reference. In pursuance to the powers conferred under Clause 1 of Article 239 of the Constitution, the President hereby directs that kindly correct. My apologies. The President hereby directs that, subject to his control and until further orders, the Lieutenant Governor of National Capital Territory of Delhi shall, in respect of the matters connected with public order, police and services, exercise the power and discharge the functions of the central government to the extent delegated from time to time to him by the President in consultation with the Chief Minister of the National Capital Territory of Delhi, except those cases where, for reasons to be recorded in writing, he does not consider it expedient to do so. This is how the LG comes into the picture. This came to be substituted by the impugned notification. There was already this notification, my lord, in the year 1990. This is now further clarified in the impugned notification. Now, my lord, so my lord, I am clearing the ground for All India services. IAS, they head the department. Now, kindly see Denic services, the second tier of administrative setup. There are 33 services which are part of Group B Central Services. Amongst these 33 group services mentioned at serial number 28 and 29 provide for services for combined union territories, namely Delhi, Andaman Nicobar, Lakshadweep, Daman and Diu, Dadra and Nagar Haveli, they called Denics. Officers are, police are Denics, but we are not concerned, police is not with them. That subject is not with them. It is submitted that Denic service is a feeder cadre for All India services, namely Indian Administrative Service. In other words, the Denic officers can be promoted to Indian Administrative Services, promoted to. There are many Denic officers who work as special secretaries in Delhi, other union territories which are governed by Denic rules. All of them are union government officers working for the affairs of the union. Well, then I have said they are selected by UPSC in page 98, which I'll skip. Then, my lord, kindly come to 100. It is submitted that National Capital Territory of Delhi, so and so Denic Service Rules 2003 are made by the President of India. Lord, my lord, the Chief Justice's question in 41, that which are those rules? Chief Justice of India, President of India, in exercise of powers conferred by the proviso to Article 309 of the Constitution, the relevant provisions are mentioned in definition clause so and so. Administration means the government of National Capital Territory of Delhi in respect of national so and so. Administrator means the administrator appointed under Article 239 of the Constitution for union territories of so and so as the case may be. My lord, here administrator we read LG. Appointing authority, my lord, please note this and my lord highlight this. Can't be highlighted, my lord, in digital version, my lord. Otherwise we.
No, it can be
No,
helpful.
it can be.
I'm sorry, my lord, I'm sorry.
It's being highlighted.
Lord, I am at a KG level of Lord, this, because of your lordships, Lord. Not because of your lordships, due to your lordships.
No, it is good that you have got the admission.
Yes, I got that.
KG or no KG?
And
My judicial clerk told me just 2 days back that you use the preview option. If you use the preview option, then you'll be able to highlight. If you're using in the Adobe version, sometimes there's a problem in highlighting in some of these PDF files.
no, we use liquid text.
Oh,
I don't know, maybe Adobe is and liquid text is same, Lord. I do not
oh,
know.
you're not working on a Mac. But just see, you'll be able to, even on liquid text, I haven't used liquid text, but I'm sure you have a highlight option.
Both have the option.
Yes, there is.
There they are.
There is.
Yes, watch out. Okay.
Right on the top of the.
The color, you can color also. But the pleasure which Dr. Singhvi and me are getting, my lord, with that broad nib pens we are missing. I think there would not be any.
There is a broad nib pen even in the preview options.
Your lordships are right. Well, that I know. Lord. There are several options. We have only one nib. Lord, here there are several. Your lordships are right. I stand corrected. Then, look, can you see appointing authority? In relation to any grade means the authority empowered under the central services, classification, control and appeal rules to make appointment to that grade. Then, my lord, cadre, services, then composition of services. Then kindly come to Rule 12. Lord, at the foot, the same rule, Denic Rules 2003. Every members of the service allocated to an administration means NCT Delhi, your lordships have read the definition, unless he is appointed to an ex-cadre post or is otherwise not available for holding a duty post owing to exigencies of the public service, be posted against a duty post under the administration by the administrator concerned. The administrator is LG. By definition, Article 239 defines, and this rules also define. Then allocation of members of the service. The government shall, from time to time, allocate a members of the service to any administration for posting in terms of Rule 12. The government obviously means central government, because it's a joint cadre of several UTs will post officers of Danics for being posted by the LG. These rules are also not under challenge. It is submitted that Denic rules further state that vacancies in Denic shall be filled on the basis of civil service examination conducted by the UPSC. Your lordships can skip and come to DAS. So DAS is the third tier and Lord, the last tier. Lord, may I take 15 minutes after lunch? Only 15 by the clock.
You can continue.
I have to.
Only 3 paragraphs are there.
Now, 3 paras you want to complete right now?
Please, Malas,
I
will barely finish at 4 o'clock. Your lordship has got mentioning. I will barely finish at 4 o'clock.
May I have your lordship's leave to mention, my lord? Would your lordship be allowing us oral submission?
Because Your lordships,
Right,
had,
I see.
your lordships had rejected this prayer on Thursday If your
I
lordship
don't
has
think it
Balas,
behoves Dr.
applications
Singh
on
is
either
trying
side,
to say
we
things
can have
like
so many
this.
applications, Balas.
All
Where
right,
assistance is to be given to the
we've
constitution
got
bench.
mentioning at 2 o'clock, so we'll take up mentioning. Do you want to take mentioning at the end? So mentioning end में
My
रखिए.
lord, I just want to know, would your lordship be hearing me, my
Anyways,
lord, orally, or
all the
would you
members-
want?
We'll circulate a notice
Yes.
that we'll commence at 2 o'clock and we'll take up mentioning after CB is over.
Kindly.
So we'll take.
My lord, would your lordship be hearing me, my lord? I just want to know,
Lord, I'll just make a request. I'll tell you, Lordship, why.
I will also have associations then, Balas. What's the point of it, Balas? This is really a.
There is no-
association.
Mr. Sarve, now everything has been covered by.
On Prem Kumar Jain, that Mr. Salve, we have, he said, I will deal with, he said, all right, I will not.
Balas, that's not fair. With great respect, Balas. This
This is a matter where, light coming from anywhere.
I've never heard of Balas.
All right, we'll
interveners
see.
coming.
We'll see. We'll see. that
Interveners
2 o'clock.
coming with this kind of time constraint, Balas.
whatever you want to say.
Yes.
And thereafter, what all that we'll do is that Mr. Salve, only on Premchand Jain, can give us a note, or you can treat it as your note and give it to us in writing. That's all.
No,
He is the sizer of the proceeding. He doesn't have to rely on Mr. Salve. He is the master of the. So he can deal with it, and
Nobody is master. Nobody is.
You can also give us the note, no problem.
rely on
I'm
association.
not addressing, I'm not arguing on behalf.
What you can do is that you can give us the note even tomorrow or day after with a copy.
Yes,
of
yes.
Dr.
We can both
Because
give one
that
page
will-
note on each.
Yeah, one-page note. You can give your one-page note
Yes,
to Dr. Singh by tomorrow. You can
Much more
circulate a
satisfactory.
one-page.
I leave it at that. I leave it at that. Only.
But we'll require an answer from you on Premchand Jain, how you are approaching it,
Incidentally, he doesn't find a mention in his written.
That, my lord, we had, my lord, honestly speaking, we as lawyers had a detailed discussion. I don't know why should we be afraid of, my lord, Salve addressing on 10 for 10. We
No,
will discuss.
that's not the point so much.
said
It's
argue
about
for
the
him. It's
modalities
with
of our
Salve.
institution, Ben.
Not be given 10
Frankly,
minutes for the-
frankly,
There is a
Mr.
discipline of
Mehta,
the court with respect.
normally, as you know, in my court, I mean, any intervener comes, we'll hear you for 2 minutes. It's easier that way.
Yeah, I'm
In a
sorry,
constitution bench,
I was
constitution
done.
bench to
Logging in
allow
issues.
some
Never done.
IAS Officers Association, there's some point in what Dr. Singh says, don't politicize it between associations. Therefore, you can say the same thing. We'll give, you can put a note on the record.
I understand Dr. Singhvi's concern.
Yeah.
I understand Dr. Singhvi's concern. But I can't argue, my lord, beyond that.
Now, suppose after Mr. Salve, Dr. Singhvi says, well, tomorrow there's some intervener. What do we do? We'll have what sauce for the good,
Yeah,
sauce for the gander.
Anyway, my lord, it's not for me to, my lord,
Isn't it?
defend.
No, I don't want to push, my lord. Your lordships don't want to hear, it's perfectly all right.
And you can give us a small note.
Yes,
and that's-
obliged.
Yes.
So, my lord, I would, your lordship wants me to give a note or even that your lordship would not want to encourage.
There's no difficulty. You can give us a small note.
Within
Just give
X
it to.
days, 1 day or 2 days.
So long as he doesn't argue, my lord, Dr. Singhvi may not have any objection.
Sorry.
So long as Mr. Salve doesn't argue, you won't mind.
So
that.
long
That's all
as
right,
you
my
don't
lord.
back
All
to
this-
Mr. Salve, I have
We
no
all know, my lord, this has
So
nothing
long
to
as
do
you
with
do not
association.
blatantly back from Mr. Salve while saying that you're not batting for him and don't set up an association of which you
No,
concede
this
that
is
you
not
have the
setting
power.
up.
I am not
What if
setting
I was
anyway,
to say
my
I
lord,
am
it's a
assisting
All
the
right, all right,
solicitor and
all
I
right.
want to take
All
15
right,
minutes?
all right. We'll now, Mr. Solicitor,
Let's not go that way.
Yes. The third layer.
My lord, we were on, and I'm skipping, my lord, something which may not detain your lordship's attraction, my lord, much. Lord, I was on page 38, and I'm
Yeah.
wrapping up, my lord. Is Das. I'm not reading Das, my lord. Das is, my lord, subordinate services, where the appointing authority is the chief secretary. My lord, that's all. I have quoted the relevant rules. The rules are framed, my lord, by the central government, and, my lord, these are central rules, and the chief secretary is the appointing authority. I don't think, my lord, anybody would be fighting for control over Das. Lord, in fact, this word control over bureaucracy itself is a very derogatory word.
And DAS postings are done by whom?
Chief Secretary.
By the Chief Secretary.
By the Chief Secretary. Under the rules, my lord, can you have a look at, my lord, the rules, my lord?
And the rules,
Page
the
59.
CCS rules,
And
the
that's
rules,
Yes, CCS rules, yes.
and also the.
No, even Danic rules, even Das.
Then it won't apply.
So Das has rules. Lord, please have a look at para 106.
Oh, then.
106. Rules, that is Delhi Administrative Subordinate Service Rules, are made in exercise of the powers under the proviso to Article 309. Then your lordships would come to, my lord, kindly come to 2B. Appointing authority in relation to grade 1 means the chief secretary, and in relation to grade 2, 3 and 4 means the heads of department concerned for the purpose of these rules, as well as central services, classification, control and appeal. That's all. But they are central services, my lord, that's all I am saying.
right.
Now, your lordship, my lord, the Chief Justice of India, my lord, pose a question. That what happens, my lord, when there are appointments to be made? My lord, the Dr. Singhvi said that we wanted to make some appointments, and there was no resistance, my lord. Fortunately, he also didn't say, but we can't even make appointments. But we can't help it. That's the statutory regime, the appointment, recruitment, etc. is done by UPSC and, my lord, as per the statutory rule governing. Please come to, my lord, page 42, the last point, my lord, in this written submission.
Posting and transfers.
Posting. The power of creation of civil post has been delegated by the President to the Honorable Lieutenant Governor with a notification dated so and so, not.
Where are you reading?
I'm sorry.
118.
118, para 4, page 42.
118.
118.
Page 42, para 118.
Yes, posting regulation.
Yes.
The power of creation of civil post has been delegated by the President to the Honorable Lieutenant Governor with a notification dated 13th July 59, not under challenge. All civil posts in the government of National Capital Territory of Delhi are governed by the Central Civil Services rules as per the aforesaid notification. All such posts are services under the Union as per entry 70, list 1. All gazetted posts same are filled by exams conducted by UPSC from time to time, whereas all non-gazetted posts filled by Delhi Subordinates Service Selection Board. LG doesn't make their point. As per transaction, this is relevant. As per transaction of business rules of NCT of Delhi, any minister may recommend the creation of new civil post in pursuance of a policy decision which is placed before the Department of Finance, GNCTD, because it needs financial approval, but finance of the Delhi government elected wing in accordance with the rules, and thereafter before the Council of Ministers of GNCTD. The decision taken by the Council of Ministers is forwarded to the Honorable Lieutenant Governor for his approval. Upon approval by the Lieutenant Governor, which is always granted if the proposal is not in conflict with any legal provision. So that is under 239AA4. The proposal is given effect to and the recruitment process is carried on as per the process prescribed in the cabinet note, or else the same is forwarded to the Delhi Subordinate Service Selection Board conducting the recruitment exam in accordance with the rules framed by the framework. That's all, my lord. Minister originates the proposal, it goes to Finance Department of Delhi, Finance Department approves, it goes to Cabinet, and my lord, the LG forwards it for the appointment unless it is, my lord, contrary to some law. That's how, my lord, this is created. My lord, now the position is this. Before, my lord, I answer the question of Jammu and Kashmir. Now the position is this. My lord, your lordships are requested to examine whether Delhi has the power under entry 41 rule, under entry 41 list 2, without they showing how they fall within. I have shown, my lord, three things. Insofar as it is applicable to Delhi, that is to union territories, and therefore your lordships will examine whether any union territory can do this. That will be the test. Union territories, my lord, kindly recall.
Yes, yes.
I have also pointed out to your lordship statutory rules or rules framed by the President under Article 309 proviso, which are not under challenge, conferring something completely different than what they are praying for. They are not under challenge. I am pointing out statutory notifications of the President, which are not under challenge, except 2015 notification. Lord, which, I'm sorry,
Yes.
which is a notification traceable to Article 239, read with Section 41 of GNCTDA. So, if your lordships were to hold that the entry falls with union territories, not necessarily, it would temper with 239AA3A, which says union territories, then even Lakshadweep can have their own service. Your lordships ultimately be setting aside the statutory rules without there being any challenge.
Yes.
And most importantly, my lords, a very harmonious structure which is in existence since beginning of the union territories will be disturbed because of some hypothetical problems being, my lord, highlighted.
Right.
Now, my lord, coming to the Jammu and Kashmir, my lord, and that's, my lord, the last submission. My lord, please take, my lord, the act. My lord, Jammu and Kashmir, my lord, it's volume 1. My lord, it's volume 1, page 1478. PDF page 1478. No, I'm sorry, P1482.
Volume 1 means convenience compilation. Convenience compilation.
Convenience compilation.
1478.
Lord, I would make, my lord, my submission of Article 4 read with Article 246, good. I have examined that, my lord, in detail. Why, my lord, Jammu Kashmir
1478.
1482.
1511, my lord, PDF page 1511
No, no, PDF
is my lord, the relevant provision, which
1511 is the relevant portion.
section 93 of state reorganization. Act. My lord, please bear in mind, this is the state reorganization. Act.
Which section you want us to see?
90.
Which section?
93, my lord, 93, which my lords would find page 1511, PDF page 1511. Your lordship,
1500 is the second schedule.
pardon me?
1500 is the second schedule.
No, my lord, PDF page 1511, my lord, otherwise 1507. If your lordships are looking at the right side pagination, 1507, section 93.
Yes.
The Public Service Commission for existing state of Jammu and Kashmir shall, on and from the appointed day, be the Public Service Commission for the Union Territory of Jammu and Kashmir. There was, my lord, this is a sui generis my lord, case.
Yeah.
Where there was already an existence of Public Service Commission. It became UT. It is continued under section 4, read with 246.
Yes.
Lord, kindly, my lord, have a look at section 4 once again. I'm sorry, article 4 once again. For, Lord, I think I'll be able to make this submission. First is, my lord, 3. Kindly see article 3. Formation of new states, and your lordships would recall, Lord, state here may include union territory. Please see. Formation of new states and alteration of areas, boundaries, or names of existing states. Parliament may, by law, form a new state by separation of territory from any state, or by uniting two or more states or parts of the states, or by uniting
So according to it, it's a supplemental, incidental and consequential provision under section
provisions which would not be treated to be an amendment of the Constitution. My lord, a Constitution bench had an occasion.
Okay. We got your point. We got your point.
I'm sorry, my lord, one more thing. This very provision came up for consideration before a Constitution bench of your lordship. Can I read, my lord, only 2 paragraphs?
Which is that?
Lord, that, my lord, we have given, my lord. The book, my lord, we have given the citation. Lord, here, when Punjab and Himachal were separated, the number of legislative assemblies were changed, which clearly amounted to amending the Constitution. So there was a clear breach of Articles 170, clear breach. Lord, that is Mangal Singh and another versus Union of India, 1967 SCR, 1967 2 SCR 109. Lord, can you come to 5, para 5? I'll read, my lord, the relevant part of it. Para 5. So there were changes in the legislative assembly numbers in violation of 170, Article 170. Constitution of Legislative Assembly of Haryana. Well, let me read 4. Section 24 of the Act. It is provided that the total. I'm sorry.
1 second. Which AR? You got an AR actually.
Here got AIR.
AIR, my lord, your lordships have.
Mangal Singh.
Mangal Singh versus Union of India.
The paragraph should be
No.
different.
That's a different Mangal Singh.
This is a different Mangal.
Starting is by section 24.
1 second. Name.
No, it's not even a constitution.
So this is some CPC. Order 22.
Lord, this is by my Lord Justice J.C. Shah.
No. Bhargav.
That is page 944, brothers. Page 944.
Lord, 944. I'm sorry, we gave 944 only.
We are
AIR.
having AIR.
There's a Mangal Singh versus Ratnu Devi.
AIR 1960. It may be our list also.
944.
AIR 1967 SC.
The first volume.
There is no
First
इसमें
volume.
नहीं है.
first.
First volume दे दो.
Appears to be mad. Our mistake.
And because that was 3 judges, I was wondering how, it's not a CB.
No, my lord, this is a CB. This may be a larger bench because in those days, maybe there was not necessarily a reference, but maybe a reference also, it's not coming out. By Chief Justice Subbarao, Justice J.C. Shah, Justice S.M. Sikri, Justice Ramaswamy, V. Ramaswamy, and Justice C.A. Vaidyanathan.
मिला आपको भी भेजो
Council will hear.
No, I would like the Lordships to read, because this would, my Lord, touch upon that when it is a state reorganization, all incidental provisions, even if that amounts to amending the constitution, is permissible. It's a, my Lord, highest plenary power of the parliament. My Lord, kindly come to the my Lord, para, whichever is your Lordship's para, which starts with
para 6 actually.
By section 24, your Lordship, sir?
No, actually in para 6, the law so made may also, second column, may also make supplemental, incidental and consequential provisions, which would include provisions relating to the setting up of legislative, executive and judicial organs of the state, essential to effective state administration under the constitution, expenditure and distribution of revenue, apportionment of assets and liabilities, provisions as to services, application and adaptation of laws, transfer of proceedings and other related matters.
On next page. Kindly read the next one.
On the plain words of Article 4.
On plain words of Article 4, there is no warrant for the contention advanced by counsel for the appellants that the supplemental, incidental and consequential provisions which by virtue of Article 4 Parliament is competent to make must be supplemental, incidental or consequential.
So under the Reorganization Act, they could have made these provisions.
And my Lord, Parliament possibly knew that it's going to be state again, it's a temporary phase. I can't, my Lord, make that statement here, but it's always, my Lord, desirable that.
Now, Premchand Jain ke baare mein unko kuch?
Another Jain, my Lord, can address for 5-7 minutes.
All right.
The last point, and for 3 minutes. My learned friend, my Lord, rightly said that there is a judgment of Bir Singh. That's a constitution bench judgment. There the question was that a person who is a scheduled caste or scheduled tribe in other states, would it be a scheduled person or scheduled tribe in another state? And that happened from the NCT of Delhi. My Lord, the court, I'm not relying upon, my Lord, it doesn't touch 239AA. I'm very honest, my Lord, candidly saying, I'm not relying upon for 239AA. But after examining the administrative hierarchical infrastructure of Delhi, the court said that these are all central services and applied central reservation for GNCTD also.
What is the citation of that base?
2018, volume 10 SCC 312, para 43 to 69.
Volume 1.
Lord, my learned friend stopped at reading 42, last line, which says that we are not touching 239AA. It doesn't, their Lordship did not touch. But thereafter, the court examines the entire infrastructure, the rule provisions, and holds that it is a central service. All India Services Act, classification, CC rules, classification and rules, every rules, my Lord, are examined. And this is the finding record. That's all. My Lord, if your Lordships can give 10 minutes.
Thank you, Mr. Solicitor.
I'm immensely grateful, my Lord, for a more than patient hearing.
I believe the union has not chosen me to address on Premchand Jain because of any connection of mine with Mr. Prem Kumar Jain.
Is it Premchand Jain or Prem Kumar?
Prem Kumar Jain. Prem Kumar. If your Lordships may kindly come to
bookmark 52, volume 1.
Where is the judgment?
The judgment is at
Volume 2.
bookmark 52,
Volume 1.
No, is it
Volume
volume 2?
Volume 1.
One.
Bookmark 52.
Page number?
Page number 4146 PDF page.
Starts at page number 4142.
PDF page is 4146.
4146.
Yes.
Lordships have the page?
Yes. 4146.
Yes.
If your lordship sees, paragraph 2, this is what Dr. Singhvi also did, but thereafter he migrated to
Para?
para 7. I would have to, my lords, comments from paragraph 2. Just to tell you, lordship, this was the paragraph read by Dr. Singhvi as well, but thereafter I believe he shifted to paragraph 7. So the core controversy, which was being decided in Prem Kumar, was not brought to your lordship's notice. So if your lordship sees para 2, a new cadre of the service was constituted for the union territories of Delhi and Himachal, and recruitment to that cadre was made directly without complying with the requirement of Rule 4.1 of Indian Administrative Recruitment Rules 54, hereinafter referred to as the rules, etc., which prescribe the normal method of recruitment to the service. The rules were amended on December 2167 by providing for a joint cadre in relation to UTs and Northeast Frontier Agency, and the central government formulated the aforesaid recipe to extend the Delhi Himachal Pradesh cadre to all union territories by absorbing the officers of that cadre and by appointing to it officers of the Indian Frontier Administrative Services and all other union territories at its initial constitution. The joint cadre for all the union territories was brought into existence from January 1, 68 by GSR so-and-so, published so-and-so, and thereafter it says the petitioners in the High Court challenged the creation of new joint cadre for all the union territories and the appointment of some of the respondents thereto. It was urged in the High Court that the constitution of the new joint cadre was illegal as it was contrary to the provisions of Article 312 of the Constitution and All India Services Act 51, as it was not common to the union and the state, inasmuch as a union territory was not a state, and the recruitment of the respondents concerned to the joint cadre was contrary to the provisions of Section 3 of the All India Services Act 51. If your lordship sees this Section 3, it would be, my lords, at page number 824, volume 1. Section 3. PDF page is 824, my lords.
Sorry, at page?
PDF page should be 824, your lordships. This is the All India Services Act 1951.
Same
Just
volume.
serial number, same volume. Is it serial number 8? 9. Serial number 9. Sir.
Yes.
It says, my lords, the central government may, after consultation with the governments of the state concerned, including the state of Jammu Kashmir, and by notification in the official gazette, make rules for the regulation of recruitment and conditions of service of persons appointed to an all India service. So what your lordship sees here is that there is a mechanism of consultation which is contemplated here. So the argument was that if union territories which are not state, and if they are taken to be equivalent to the state, then how will they consult themselves? Was the sort of conundrum which was contemplated, which lordships will emerge little later. It says further in para 3. The High Court examined the question whether the union territories were states and reached the conclusion that this was not so. It therefore held that Rule 4.5 of the recruitment rules was ultra vires the Constitution and the All India Services Act, for the cadre in question could not be said to be in common to the union and the states. The High Court also observed.
Yes.
That the central government was itself the state government for purposes of a union territory. The central government could not consult itself within the meaning of Section 3. So this was the problem, my lords, that they posed for themselves. The Honorable High Court had posed for itself. And then, my lords, they on the interpretation that a union territories cadre, because at that point in time, the union territories, the placements in union territories was being done from Himachal and Delhi cadre. So after Himachal became an independent state, then there was a need for making a UT cadre. So what was initially done was that all union territories were clubbed together and a solitary union territory cadre was carved out. And later on, it was in any case in 1972, this problem was resolved when the joint cadre and the cadre control rules, etc. were formulated. Eventually, after when Meghalaya was carved out from Assam. So for a brief period, there was a grey area. So during this period, this question arose. And their lordships, in fact, relied on same, my lords, 358 of the General Clauses Act, which is, my lords, backed by Article 372 and 372A. And 372A was brought along with the 7th Amendment when a State Reorganization Act was brought and union territories were created. So this was very simply answered by the lordships in Prem Kumar, that for the purposes of all India services, we can include union territories and we can read them as a state for the purposes of cadre allocation. So that was the limited point. And this is what your lordships have also dealt with in paragraph 458 and 459 of Constitution Bench judgment of 2018, your lordships. If I'm allowed to read 458.
Para 8 actually.
488. 881 of the first one.
Four double
488. If your lordship sees, in Union of India versus Prem Kumar Jain, a bench of, sorry.
Yes.
Our Lordship Justice Kohli have it. This is
Kohli.
4881.
Give me a moment, isn't this 4881? Right. Yes.
It's para 458, Lordships. In Union of India versus Prem Kumar Jain, a bench of 4 judges of this court dealt with an appeal from a decision in Prem Kumar, which is Union of India of Delhi High Court, which had quashed a notification of the union government and a scheme for the formation of a joint cadre of the Indian Administrative Service. The High Court had held that formation of a Delhi-Himachal cadre of service to be ultra vires. The creation of a joint cadre for all union territories on 1168 under Rule 3.1 of IAS Cadre Rules 54 was challenged as being contrary to Article 312 and All India Services Act 51, as it was not common to the union and a state, a union territory not being a state. The High Court held that union territories not being states, the action was ultra vires. In appeal, this court observed that it was not necessary for Parliament to make a law providing for the creation of a service common to the union and states under Article 3121 in view of clause 2, which provided as follows. And then 312 is quoted by your lordships. It says, the services known at the commencement of the Constitution as the Indian Administrative Service and Indian Police Service shall be deemed to be services created by Parliament under this article. So that was a deeming fiction, and then your lordships have held. Section 3(1) of All India Services Act had a provision for making rules for the regulation of recruitment and conditions of service of persons appointed to an All India service after consultation with the government of the states concerned. The issue was whether UTs could be states for the purpose of such consultation. This court held that the expression state having been defined in section 358 from the commencement of the 7th Amendment to the Constitution in 56, and the President having substituted a new clause 58 in section 3, there was nothing repugnant to the subject or context to make the definition inapplicable. The High Court was held to have been in error in holding the UTs were not states for that purpose. Now in 459, it has been observed whether the expression state in the Constitution would cover a union territory is a matter to be deducted from the context. So this exactly, my lords, is our submission with regard to the entire conspectus of controversy, that whether this entry 41 in list 2 has to be constituted as being available to GNCTD or not is to be seen in the context. And merely because in a particular definition it is stated that a union territory in a given context may be constituted as a state, it doesn't mean that it is there, it is so in all respects. And this exactly what your lordships have clarified in 463, paragraph 463. If I come at the bottom of, let me just conclude, my lords, then I will come to paragraph 463. I am reading from fourth line. Hence, the inclusive definition of the expression state in section 358 of the General Clauses Act cannot apply to the first schedule. Similarly, in Article 246(4), which enables Parliament to make laws with respect to any matter for any part of the territory of India not included in a state, the definition of 358 would have no application, having due regard to this context. So this is, my lords, a very clear finding. Your lordships have clarified this aspect, that while exercising any power under 246(4), what are the parameters available? And this was explained in the decision of Kanya. When there is something repugnant to the subject or context, the definition of 358 would have no application. And this, read in conjunction with 463, if your lordship just scrolls down and sees paragraph 463, and just above placetum G, 3 lines. Hence, the expression, insofar as such matter is applicable to the union territories, is
Yes.
In fact, my lords,
You've got, now you've got understood from that,
Not just to
two
conclude
paragraphs
the
make
point,
it very
Lords.
clear.
Just to conclude the submission, your lordships, to say that Prem Kumar Jain has the effect of making Part 14 available to the Union territory is a completely misconceived proposition, because the context of Union territory can be gathered from other parts of the Constitution. We don't have to go to that definition of 358 in this, because it is available from 239 AA itself, because it is clarified, because when 239 AA is structured and dedicated only for the governance model of Delhi, then one need not travel anywhere beyond.
That
And
is
if we have to
considered,
see-
that is considered by learned Chief Justice saying para 358, sorry, 458 to 463.
Yes, yes, Lord.
It has already been
Yes,
considered.
this has been taken.
Indian judgment is also concerned 9 bench taking a contrary view. The state does not, Union territory does not mean the state, etc. That has been dealt with and considered.
My lord, this is exactly the proposition. So I am here, my lords, only to clarify this aspect, that so far as Part 14 is concerned, it does not, my lords, even by implication, suggest that this is available to a service, or this can lead to a creation of a service other than what is contemplated in Part 14 is, and it has to be seen from the lens of Article 308 and 309, which make it abundantly clear that what kind of services are contemplated in Part 14. That's all.
Thank you, Mr.
Very grateful.
Thank you, Mr. Yes, Dr.
Please, Your Honor. There is just a word about the logistics. We have been taking notes from the last Thursday when he had argued sometime and made a rejoinder note. Then we tried to keep on updating it on the computer here till about 11:30. Then we ran out of minutes, so we've got a rejoinder note sent to your lordships. So I'll do
Yes, we
that.
got your rejoinder.
I'll do that first.
It's there.
Then, I will do equal number of points on the balance part of his arguments till lunch. So I'll do about 20 broad heads of points, and I'll be very, very pointed and quick. I appreciate the time. I know we are racing against time. Your lordship, sometimes exceptional circumstance gives me a little over 4 if necessary. I will not repeat. I'll be very fast. Now, my first preliminary point, and that preliminary point is important. Forgetting all the details we'll come to, is that I beseech your lordships, especially in rejoinder, this is important, that this is a case about all the points we have both argued and are going to argue. But it is equally, a case about black and white, about clarity, about minimizing areas of grey. If I may say so with the deepest and genuine respect and humility, look at the clarity in this case. It starts in the High Court Division Bench. It goes to the Honorable Supreme Court. The Supreme Court, that is number 2. Number 3 refers it. The third stop is the Constitution Bench. The fourth stop is a further division bench of the Supreme Court. 3-judge bench. Now, why should your lordship at all be having a Constitution Bench? Because according to me, and I may be wrong, but I do believe that your lordship's tried, as your lordship does, perhaps to reconcile and harmonize. And there, the black and white got sometimes blurred into grey. That is certainly not what I would want, but I believe that is also not what your lordships would want for the future. That this litigation recurs because of, as they say, you can't please everyone. You can't even half please everyone. And this is something which is going to recur unless there is a certain clarity. It has to rest broadly on black and white. Related to this point, I am not seeking any largesse from anyone. I am seeking my right, my constitutional right, as an elected representative government. I am not seeking my learned friend's sufferance or largesse that he'll give me something or not give me. I am seeking the realization and the actualization of the only animating purpose of 239 AA. Because 239 AA is in the constitutional book, nobody can negate it by saying, I don't recognize 239 AA. I dilute it by a parliamentary enactment. Nobody can do it, your lordship knows that.
But
equally, there are ways of
what is it
circumventing it and reducing it.
what is it that the GNCTD really seeks? I mean, is the now what you really seek clarity on is that you must have the power to post officers, or what is it that?
No, Manoj, that's the example we are putting in. We seek clarity on this, Manoj. NCT, I'm going to harmonize. I'm not against harmonization. I'm going to harmonize.
At the end of it, if we are with you, what is it that you would?
Yes.
The clarification.
NCT. I mean, this is oversimplifying. This is the beginning of my rejoinder. I'll oversimplify at the risk of oversimplifying, but I'll be elaborating. So, Lordship will bear with me. Jammu and Kashmir will come into it. The civil service rules will come. I've dealt with everything. But just to answer my Lord's question directly, and as well as forthrightly as possible, I am seeking what is rightfully mine in legislative terms in entry 41. That's the first answer to my Honorable Chief Justice's question.
Just a second.
My legislative rights in 41. As indeed all my legislative rights, that's the second answer to my Lord Chief Justice. As indeed all my legislative rights under every entry of list 2 minus 3 entries. I'm being blunt because this is not the way to put it. I must elaborate first, but I'm doing it the reverse order. So Lordship will allow me to elaborate after this. Thirdly, I am seeking all those executive rights and powers which go with this A and B. That's my C. The effect of this is D. The inexorable effect of this is D. Namely, that even as per their own rules and as a necessary consequence of A, B, and C, I must have the right to choose whom to post where and whom to transfer where. But that, fellows, will fit into the legal harmonization above of ABC. It's the inexorable and inevitable consequence of ABC. So this is, fellows, the more... But let me just continue with my theme. The first theme was, fellows, perhaps your Lordship would not want this situation to recur for lack of clarity. And as I'm reminded, in my student days, Margaret Thatcher had this famous phrase that if you stand in the middle of the road, you have danger of being struck down by traffic from both the right and the left. That is not against reconciling and harmonizing, but sometimes, as these cases illustrate, your Lordship, with the best of intentions, bona fide, may not solve the problem which has been harassing this court for 3 or 4 hours.
2 swords in the same sheath.
2 swords in the same sheet is Dr. Ambedkar's formulation, incidentally, was for the governor, and your Lordship remembers, just to digress for 30 seconds.
Cuts both
in the Constituent Assembly, absolutely correct.
It cuts both ways.
Scabbard was used, or sheath, I don't remember. Very interesting. In the Constituent Assembly, there was a direct proposal, debated for more than a day, that the governor should be like a chief minister. He should be a nominee who is actually exercising executive powers, or at least far more than today's governors do. Then that phrase was used, Justice Narasimha has just opined. So, and who's going to do it? Who's going to demark it? Only your Lordships. Therefore, that poet Frost put it even more interestingly. He said the middle of the road is where the white line is. And that's the worst place to drive. Since your Lordship is talking so much about gears and clutches and cars and steering wheels, it's the worst place to drive where the white line is going. And which line goes which side? Only your Lordships. All this rest of it is multiply sermonizing that we will sit together and sort it out. It will never happen. It can't happen. Your Lordship lives in a real world. And it is because we have to smell the coffee, it's only your Lordships will lay down those lines. Point number 2, I have already dealt with in paras 12 to 19. So I'm saving time by repeating what I've done in my original submission. The facilitative function and not the limiting function of insofar as. There are 7, the heart of my submission is those 7 paras actually, 12 to 19 inclusive. And within that heart, para 16 demonstrates why, for the reasons I have itemized, it is facilitative and not restrictive, limiting or reducing to vanishing point. So may I not repeat that, but I would request my lords to kindly underline and note those paras, especially 16, and take it as reread to your lordships. Take it as having been read by me. I've given those reasons facilitated. Otherwise, your lordship would have to amend. Your lordship would have all kinds of problems. And it is intended to suggest that mutatis mutandis, what it should do. It is not restrictive. That was the argument in a general sense. Then, the third set of submissions is to remind your lordship, this will be very brief and pointed because your lordship has seen it, that this aspect of insofar as being exclusionary was specifically noted in para 39 of Chief Justice Mishra, which my lord has noted at page 4773, para 13, specifically. And I read that to your lordships in the opening with immediately after 39, para 222, 223 and 224, where the scheme of distribution of legislative and executive powers is discussed by the same judgment. Read together, it is clear that insofar as has been decided by your lordships in the Constitution bench, not to mean what the government of India is today canvassing. So read 39 with 222, 223 and 224. This 223, 224 is 4773. I'm sorry, Manus. 39 is at 4714. I gave the wrong page to lordship. Para 39 is at 4714. Para 222, 223 and 224 is at 4773. Then, Manus, the judgment further in 224, it's a very important para to repeat, Manus. After noting, that is 224, para number, page 4773, says clearly that all entries are available minus, it says that except 1, 2 and 18. And Balabs,
Which is that para?
that is 224, 4773. And your lordship will now turn to my written joined note. It's quoted there.
Para 2. Para 2.
That
Para 2 of your.
I'm grateful. No, para 3. My lord is right. Para 3.
3 also.
Lordship will just see the last small Roman 3. That will be quicker. Your lordship doesn't have to go to 224. Such an interpretation would thwart so need not go to 224, just see it from here. May I read, Manas? Such an interpretation, and that such an interpretation in the preceding part is exactly what is argued today, would thwart any attempt on the part of the Union government to seize all control and allow the concepts, mark this word, pragmatic federalism and federal balance to prevail by giving NCT of Delhi some degree, there is some misprint there, of required is wrong. Yes, I'm sorry.
Required independence.
Now, your lordship may note here, because it's better to note here itself to save time. This word pragmatic federalism is dealt with by Chief Justice Mishra in paras 125, 127 and 128. Para 125, 127, 128, especially the last two. So, Malas, before I come to Chief Justice Chandrachud's judgment, Malas, if this is left open textured, then Malas, we are opening the door to an open crisis every day. This can't be left open textured. Then Malas, Chief Justice Chandrachud in my next para 4, and which is your lordship's para 362, page 4883, says cabinet government in 239AA necessitates that the court pursue a line of interpretation which does not detract from the fundamental principles of representative government. This is just a recap. I've dealt with Westminster model. I've dealt with civil service. What is the meaning of cabinet government and representative government? If by a circular route, you are actually either diluting 239AA to vanishing point or otherwise rendering it unworkable. And your lordship's words can have only one meaning, is my humble and respectful submission. I then leave the other 2 or 3 small paragraphs for this. I now come to a very important part of this, which is the larger issue of public service commission, but in particular Jammu and Kashmir. That is coming here. Now this is very important. It's a little conceptual. I did put it, but I did not put it quite like this, which I'm now doing. So Lordship, it's not, of course, fully here captured in writing, but this is the heart of the matter. And this also answers the query which the Honorable Chief Justice asked Mr. Mehta. Let me first give you Lordship the concept, then read this part, or then explain the part. Well, the argument is not about physical existence or absence of PSCs. The argument is a very, very simple but fundamental conceptual argument on the other side, namely that a PSC is not applicable per se to union territories. Well, each of my 5 words is important. I've checked up this. Argument is PSCs, Public Service Commissions, are not applicable to union territories per se. It's not about Jammu and Kashmir, Delhi. It is not about physical existence or absence. The concept of UT and the concept of a service commission is anathema, mutually exclusive. One doesn't permit the other. Unless we understand this argument, this is the argument which I am meeting, and it falls to the ground once you formulate in these stark terms. This is the argument. So, conceptually, your lordships can't apply a service commission to a UT. Ever, any case, any UT, Delhi, JNK, anyone.
That was the way his...
That is the reason why lordship's query is very important.
Formulated, but later on the solicitor sort of modulated it in his submission.
No, but therefore that's very important. That's why now your lordship's query can be answered only after I first formulate proposition. So please take this. This is not put like this in my submission. Lordship may do with the favor of noting it or otherwise putting it somewhere else. Conceptually, a service commission and a UT cannot coexist, is the argument. That's why it's inapplicable. That's why 41 is inapplicable. That's why there is no power. Point number 2. Well, sometimes things might sound simple, but from the simplicity, flows again. If that is so, it is common ground that Mr. Mehta exercises power only over UT. As far as my case is concerned, Delhi or Jammu and Kashmir. If a concept of a service commission is anathema to a UT, how does Parliament exercise it? Cannot. We'll come to Jammu and Kashmir immediately. If conceptually the two are anathema, Parliament is today, Parliament oblique UT Parliament, if I may use that word. My lord is not considering Parliament in state and Parliament in Parliament. Your Lordship is considering a third avatar of Parliament, Parliament with UT. If UTs cannot have service commissions, then Parliament cannot enact law. Parliament cannot create either the Public Service Commission of JNK or for that matter Delhi, because as my Lord Chief Justice noted in the opening, this is a argument applies across to UTs. No, all UTs.
The argument that would be really an unfair, assessment of his submission.
Yes.
He doesn't say that you cannot have a PSC or that you cannot have a service for a UT. The argument, for instance, he says, well, you have a service. You have the AGMAT services for UTs, for instance. The point is about legislative jurisdiction. His argument is that you can have a service, a common service for UTs, but it's Parliament's power to create that service. Likewise,
I'm coming to that.
Parliament's power to create.
Immediately, please.
He says entry 41 does not apply
Therefore, that's C. I've done
Therefore,
two.
but Parliament has no restricting,
No. I'll be dealing with 97.
Entry 41 not being available
dealing with
would
97.
prevent the state legislature,
Well,
the UT legislature from enacting law.
So, what is the
But
first?
Parliament is untrammeled because
No.
if Parliament has no specific power, in any case you have power under
97,
246
no, right.
code, you have entry
Right.
97.
So, therefore, allow me to develop. So, the argument is that UTs cannot have service commission power. Let's leave aside Parliament. UTs don't have.
No. A UT cannot legislate to set up a service.
Yes, so UTs have no power about the Public Service Commission.
No, but Parliament has the power.
No, now, Parliament.
Because Dr. Singhvi, there cannot be a legislative vacuum in India at all.
No,
or
no,
in any country.
This is a created.
Because there will be new subjects which will emerge, there will be unheralded subjects.
No,
Power has to exist somewhere
Yeah, definitely.
to legislate.
Whereas what is happening is they are creating a legislative vacuum. Now, I am not reached 41 yet. Let's just bear with my first two propositions. The argument is that a UT with a service commission is anathema. Let's leave aside Parliament. Conceptually, the UT doesn't have. And because UT doesn't have, then when you go to list 2, which the UT can enact over all the items of list 2, minus 1, 2 and 18, UT can't act under 41. Right, Manus? Let's leave aside Parliament. So, Manus, first curious thing, UT can act under all legislations. There is no specific exclusionary article in the Constitution which says UT can act under 50 list 2 entries, but not under 41. But by implication, UT cannot act. That's my third point. Now, what is the fourth point? Parliament could not have enacted either Jammu and Kashmir or if it wants to try under Delhi, except under entry 41. Nothing else.
Why?
That's my submission. Allow me. Let me do.
You know, Parliament.
Entry 41 is a direct.
No, that would suffer from a fallacy, you know.
Yeah.
Parliament's legislative authority is untrammeled in.
No, with respect. Your Lordship has held repeatedly.
That's why, as I said earlier, Chief Justice Venkatacharya called this ragbag legislation. No, when he was referring to the taxing legislation, he says ragbag legislation, which is traceable to a lot of powers which Parliament has, if not anything, 97.
No, with respect. Repeatedly held by your Lordships, repeatedly, not once. 97 doesn't enter the picture where there is a specific entry in list 2. Repeatedly, that has to be, Malas. Otherwise, there will be no federalism. Malas, if 97 became, as a Lordship put it, the ragbag,
no,
then there will be no federalism because list will be swallowed up.
Dr. Singhvi, there also there's a problem with the argument. I'll tell you why. This will apply where there is a specific entry which confers exclusive legislative jurisdiction on the states.
Yes.
All right. So for entry 18 of list 2, land, that is say land tenure, land revenue, etc. So Parliament cannot exercise power under entry 18.
41, Malas. Direct entry.
No, but here what happens is, Parliament has powers over everything.
No, with respect, everything in list 2.
Yes.
Not generally. No, with respect, Malas. Parliament becomes the UT in the state list.
Right.
It doesn't mean Parliament starts exercising in the UT powers under some other list. But the whole idea, your Lordship judgment says so.
But Dr. Singhvi, Parliament, even in relation to a UT, can exercise powers under list 1.
Under the entire list 1, it always can. List 2 is available to Parliament. There's no point of having a UT.
Power to set up a public service commission within a UT can be traced to entry 97. The rest of the
entry can't because entry 41 occupies. No, with respect. Wallace.
Article 248.
Mr. Jain.
Is a residuary power.
At the moment, let me. Now, Wallace.
Sub-article 4 is.
Please appreciate this. Your Lordship is not considering a situation where Parliament chooses to pass a Public Service Commission law for Delhi. Nobody is saying they can't pass.
That's
what my Lord is considering is.
No, we were therefore saying
that your Lordships cannot have the power of the state, that is the UT legislature, to deal with 41, despite Parliament not having exercised. Now, in that a subsidiary point came in, that where is Parliament's power traceable to? Your Lordships, in fact, formulated the question in one way and then said if there's nothing, it will be 97. There is nothing, is the gap in the reasoning. It is assuming what is sought to be proved. There is something. There is entry 41. No entry can be more direct than 41, Malas, your Lordship, the Constitution Bench have said 10 times.
There are two questions really.
And your Lordship has said...
One, can the Delhi legislature set up a state public service for Delhi? One.
The answer is yes, but your Lordship will go on.
Two, assuming that the power is not given to the Delhi state legislature, can it still exercise executive authority over the area?
Answer to both is yes, because the answer is yes in the first case, therefore the answer is yes in the second case. Give me a minute, give me a minute. Just take the concepts are most important in these things, not the minutiae. Take the list 2. It is common ground until you come to 41. There on every item of list 2, Delhi Assembly sitting in Delhi, it is passing laws. Every day it is passing laws, every item of list 2. Forget 1, 2 and 18, I'm not talking of 1, 2 and 18 and 16.
Does the enactment of part 14 take away that power?
That was separate. Allow me to come. There is a very strange proposition is told to your lordships. I don't want to deal with it now. That Prem Kumar Jain says part 14 and 312 will apply. In the same chapter, same part, same section, 309 will not apply. It's the most remarkable reading of context in the Constitution. Please leave it aside. I'm coming to that. People forget, my learned friends have forgotten, that Prem Kumar Jain was on part 14, which has both 309 and 312, 3 sections apart. Same chapter. Your lordship has 1,000 judgments that unless some extraordinary words of the Constitution say your lordships can't apply X to 312 and Y to 309. But let us leave that aside.
Yeah.
Now, it is common ground that in every entry of list 2, we are suddenly told that without pointing to your lordships any article of the Constitution, you can't do it in 41. Now remember,
Is there any other entry in list 2?
Yes.
Which conceivably it could be argued is not applicable to a UT?
Exactly. I took your lordship almost 3/4 of the way down.
Right.
I read about 40 entries or 35 entries.
Right.
Well, once your lordship's 239 AA chooses to exclude 6 entries, why will your lordships at all go down the path of it being told to imagine that some more are impliedly excluded? Well, these are fundamental principles of interpretation.
Or is the word insofar as is applicable really intended to be a word which says with such
mutatis
mutandis?
Well, I argued with you. Well, it is nothing but mutatis mutandis. It fits in perfectly.
So far as may be applicable means
well,
mutatis mutandis.
Greatest humility.
That's
it's intended to mean mutatis mutandis because we are dealing with a sui generis creature. Once your lordship takes that view, it harmonizes everything. Now allow me one more thing. So my lord is today being told that 41 being as it is directly dealing with the subject. I am right here and now saying for the 10th time, if Mr. Mehta chooses to pass a law on 41, your lordship will be dealing with a different situation. What is the problem? Having not passed a law in 41, having passed no law in 41, why is he going back to 97? Note that judgment, Justice Rumapal put it very well, brothers, in that judgment. Give me that. There are any number, brothers, it has to be. Otherwise, brothers, if you use a residuary entry to trample over list 2, there will be no federalism left. Now, let us kindly see that. Give it to me. Line it. I'll just give you a lot of something. That brings me to the 4th aspect. You are Parliament. You have admittedly a UT. Well, this is an example of being hoisted on your own petard. You have a UT. you have enacted a law, but when faced with the direct of a public service commission for a UT, and your lordship in the opening asked me, UTs include Delhi and non-Delhi. So it can't be a law that UT means different for Delhi and UT means different for Jammu and Kashmir, as far as the concept of UT is concerned. Now, how did you enact a law except under 41? When your lordship put that question, the answer is no, I elected. First of all, there's no answer. Your lordship gave a, if I may say so, both sides of the coin. If you did not do under 41, the only power is 97. Because of course, we would not expect. Is itself indicative of the fact that this is how the government of India stand. Not that there is any estoppel here. Nobody is arguing any estoppel in constitutional law. But your lordships can take it. The government of India has never dreamt of 97.
No, but the power is there. There's the constitutional
right.
power is there. Then
now just see 41.
From the judgment in Dhillon, it has been always said. For Parliament, you only ask whether there is a subject in list 2. If it's not in list 2, then of course.
Now just see list 2. 41. There cannot be words more directly occupying. State Public Service, semicolon, State Public Service Commission. But there can't be more direct words. Your lordship has held by implication entries to occupy with much lesser words. My lord is absolutely right. Absent 41, you might, I'm not conceding because I doubt if a government of India, which is given by your lordship's constitutional bench power to act for a UT under list 2, can start acting under list 1. That is another thing. Your lordship constitutional bench makes it clear that the difference between a regular state and a UT is that Parliament can act on list 2 subjects. Now, suddenly you go to 97 on general principles is not allowed. Kindly see the judgment. Give me the citation. 2000.
669.
Give me the citation. 2005 2 SCC 669. Well, these are many judgments. I only brought it up when your lordship suggested 97. I can take out many more in my note.
What, 97?
It's about the residual entry.
2005.
2005, volume 2, SCC 669, para 7. I'm only on the 97. I'll give more judgments because this came up right now. That's why.
Logic is not applied.
Right? Given right? Because it happened now in the court, so I'm just taking out the right one. Now, let's kindly continue. I'll come back to it. So, my lord has reached my 4th aspect under this Public Service Commission, the J&K aspect. Well, it's my 4th point is that J&K is relatable to an exercise of power by Parliament, qua a UT, only and only under entry 41. That's my humble submission.
Exercisable, relatable to the
exercise of parliamentary power for a UT, qua a State Service Commission, under entry 41. Now turn to my para 5, para 2. Please do that. Now, your lordship can now read with me my submissions, para 2.
Para?
2. Part 14 envisages services of a UT. Lordship, you got that heading?
Yes.
It was argued by the learned solicitor that neither a public service commission for a UT nor a public service of a UT is permissible under scheme of constitution, particularly part 14. This is clearly incorrect and belied by Parliament's own express understanding. The below provisions of the Reorganization Act, these are important, just read me a little slowly, demonstrate without any doubt that public service for a UT, as also a public service commission for a UT, are not just permissible, but that part 14 in fact envisages them. This is apart from Premchand Jain, which I am coming to. I am reading section 90 of the J&K Act of 2019, is quoted there for convenience. Other provisions, nothing in this section or in 89 shall be deemed to affect on or after the appointed date the operation of the provisions of chapter 1 of part 14 of the Constitution in relation to determination of the conditions of services of persons serving in connection with the affairs of the Union or any Union territory. As clear as can be, part 14. Now continue, Manoj, kindly continue. All services prior to the appointed day rendered by a person, if he is deemed to have been allocated to any Union territory under 89, shall be deemed to have been rendered in connection with the affairs of that UT. Then, if he is deemed to have been allocated to the Union in connection with the administration of the successor UT, shall be deemed to have been rendered in connection with the affairs of the Union. Then, provisions of 89 shall not apply. Now, 91. Provisions as to continuance of officers in same post. Every person who immediately before the appointed day is holding or discharging the duties of any post or of office in connection with the affairs of the existing state of J&K, in any area which on that day falls within one of the successor UTs, shall continue to hold the same post or office in that successor UT, and I underline this, and shall be deemed on and from that day to have been duly appointed to the post or office by the government or other appropriate authority in that successor Union territory, provided that nothing shall be deemed to prevent a competent authority on and from the appointed day from passing in relation any order. Now, 93 is very important also. Provisions as to State Public Service Commission. This is Parliament acting in a UT only under 41. The Public Service Commission for the existing state of J&K shall, on and from the appointed day, be the Public Service Commission for the Union Territory of Jammu and Kashmir. If it is insofar as applicable, you can't have the power, then how can you pass this law? This provision can't exist. This provision of a parliamentary law is negated by the Government of India's own argument, if this argument is correct, which I say it is not. Then, today, please remember, we are not about Parliament's power to pass a similar law as J&K for Delhi. We are about a very remarkable proposition. Absent even an attempt by Parliament to pass a law about Delhi, Mr. Singhvi can't act on that entry 41. That is the proposition your Lordship is addressing. And the fact that he can pass a law and I can also pass a law perfectly harmonizes. And if I can pass a law, obviously I have executive power, perfectly harmonizes. Why should your Lordship have to travel beyond 41 to a Central Union Public Service Commission in entry 70? A Union Public Service Commission. Why, Why does the Lordship have to travel to 97, which is a residual entry? There is a direct occupation of list 2 by entry 41. Also, please note, to complete this point, it is because of 246, which your Lordship noted in the pre-afternoon session, that Parliament can act under list 2 at all. Otherwise, Parliament can't just come rampaging into list 2 just because it's a union territory. It is list 2 which, 246 which allows it. So it perfectly harmonized. 246 takes you to list 2. List 2 has got entry 41. Parliament is welcome. I am welcome. No need to go to either entry 70 or entry 97. That harmonizes the entire circle. Now let's see how this is fortified. Your Lordship has read just now part 14 in the Act of J&K reorganization itself. It is mentioned and quoted by me. Now kindly turn to part 14 of the Constitution, textually. Is this interpretation even stateable, is my question to myself. Does your Lordship allow it for ordinary contracts or statutes or in any constitutional provision? The interpretation canvassed by the Government of India. Please come to part 14 starting. It starts with 308.
Yes.
Services under the union and the states. So here, just give me a second, Manas. Himachal and one other state arose in Prem Kumar Jain. Clearly the title is union and states. So simple argument was made, UT is not covered. Lordship sees the title of part 14. Yes. Binary distinction, union one side, state one side, there is no UT. Therefore, the High Court in the case of Himachal, held, sorry, out you go, you're a UT, you're not covered. Directly on point, Delhi High Court, and equally directly reversed by 4 judges of your Lordships. Very simple argument, see the title, services under union and states, therefore no UT. Now read 309. In this part, unless the context requires the expression, state does not include. Now let us come to 309. This is 309, first read 312. 312, no? First read 312, I'm sorry, before that, would my lords note that there is nothing, no special provision which suggests that what will apply to 312 will not apply to 309. Now first start with 312. Go in reverse order. 312 is even more important, it is all India services. Malas, this is a little important. All India services includes the basic large service, of course, IAS, etc., and AGMUT. Whereas with deepest respect, the Government of India, in trying to defend this case willy-nilly on any ground, is killing the AGMUT cadre. The AGMUT cadre cannot exist if this argument is correct. Now read 312. Notwithstanding anything in Chapter 6, if the Council of States is declared by resolution supported not less than 2/3, it necessary to expel national parliament.
After Goa becomes a state, now it's clearly the AGMUT cadre covers a state as well as the union territories. Likewise, Mizoram is also a state.
That's right. That's right.
Tripura also.
That they've created, they especially applied that cadre to that. But today, Malas, in fact, need not read it, just see 2 words, Malas. 3121 is one or more all India services, 4th line. That line alone has to be underlined. In 3121, one or more all India services. And then, subject to regulate recruitment conditions of service. Then, number 2, clause 2 talks of IAS and IPS. Let's leave judicial service in number 3, and 4. 3 and 4 are judicial service. I hope I'm clear. Now come to Prem Kumar Jain. I'm sorry, to complete. See 309 also. 309 actually is more in my favor because it is subject to this constitution, which means it is subject to 239AA also. 309 opens with the words, subject to the entire constitution. Therefore, subject to 239AA also. In the same chapter, same part, 3 clauses apart. Then read Prem Kumar Jain with me. Subject to the provisions of this constitution, acts of appropriate legislation may regulate the recruitment and conditions of service of persons appointed to public services and posts in connection with the affairs. Provided, the proviso is important for my purposes, last 4 lines of the proviso, where I'll read the whole slowly. Provided that it shall be competent for the President or such person as he may direct in the case of services and posts in connection with the affairs of the Union and for the governor of a state or such person as he may direct in the case of services and posts in connection with the affairs of the state to make rules regulating the recruitment and the conditions of service of persons appointed. Now mark these words. To such services and posts until provision is made in that behalf by an appropriate legislature. It's a transitional temporary provision. Until provision is made in that behalf by an act of the appropriate legislature and any rules.
Executive legislation.
I beg pardon?
Executive legislation.
Executive. Yes, please. Now, nobody is saying that if you choose to act and make a law, you can't do it under entry 41. Question is, having not done it, you are saying the appropriate legislature, Delhi can't do it. Because I apply the entire constitution without an exclusionary article to all the entries of list 2, but I exclude entry 41 by implication. Manas, this is, and remember, Manas, the impugned notification is not a statutory, not a constitutional, it's an executive rewrite, adding a 4th clause to 1, 2 and 18. Manas, your lordships have to face that point, Manas. You've got 1, 2 and 18 the constitution gave you, and by an executive impugned order, 2015, you are adding 41 to 1, 2 and 18. Manas, your lordships, with great respect, no canon of interpretation is told to your lordships. Same chapter, Prem Kumar Jain, 3 sections apart will not apply. Now turn to Prem Kumar Jain. Yes. 52. Bookmark 52, page, I'll use yours. Just see para 2, 7 and 8 I read. I'll not read again. Mr. Jain read it also. Exactly the same point Delhi High Court held and reversed by Supreme Court. The state here, or the UT here was Himachal and Delhi. Where is it here? Here, Manas, Delhi and Himachal, joint cadre was involved. A new cadre of service, may I read, Manas, very quickly? 4 learned judges, and Manas, with respect, Mr. Jain may have dealt with it later. It doesn't find mention in Mr. Mehta's submissions. Neither 52 pages nor 90 pages earlier. A new cadre of the service was constituted for the Union Territory of Delhi and Himachal, and recruitment to that cadre was made directly without complying with the requirement of Rule 4.1 of the IAS rules, etc.
I read it. It's part of my volume, and I read it today also.
That's all right. I'm just saying it's not part of your submissions.
Submissions. I read it. It's part of my today's submission. And I have been gone into annexed it and read it.
Then
already reference.
Read from Manas' 4th line. The rules were amended on December 21 by providing for a joint cadre in relation to the UTs and the Northeast Frontier Agency, and the central government formulated the aforesaid scheme to extend the Delhi Himachal cadre to all UTs by absorbing the officers of that cadre and by appointing it to officers of the Indian Frontier Administrative Service and all the union territories. The joint cadre for all UTs was brought into existence in 1968 January. Hereinafter referred to, skip that. The petitioners in the High Court challenged the creation of the new joint cadre for all the UTs and the appointment of some of the respondents thereto. It was urged in the High Court that the constitution of the new joint cadre was illegal as it was contrary to the provisions of 312. Why was this? One line, simple. As it was not common to the union and state, inasmuch as a UT was not a state. What does joint cadre means? It has to be government of India and a state, or 2 states. Now, Himachal is not a state, therefore out you go both the categories. That's a simple argument. Now let us come to 7. My thing is always changing. Now your lordship will come straight away to para 7, where they compare the provisions, and then come to 8. 8 is enough.
58.
It's been read, marked by our lordships, but just note, directly the contention reversed is at 7th line before the end of the paragraph. The High Court was therefore wrong in taking a contrary view and in holding that UTs are not states for purpose of 312 and the preamble. All that Mr. Jain is saying is that contextually, UTs are states for 312, UTs are not states for 309. That your lordship decide. Any great article in the Constitution so suggests? is the subject of 309 Arctic poll and the subject of 312 Arctic. Is the subject of 309 directly opposite to the subject of 312? Imagine the difficulties that arise if UTs are states for 312. UTs are not states for 309.
And what do you have to say about the legislative history argument on part 14 with the SER?
It's completely unnecessary. Completely unnecessary. Legislative history, has been legislative history has been legislative history is completely, it's very good to have all these long submissions with all the details. Very useful to have them, but they have no relevance to the case for the two simple reasons. It is superimposed by 239 AA in 92. It is superimposed by a Lordship General Constitution Bench, and it is interpreted by Prem Kumar Jain, which doesn't find a mention in this legislative history. So, yes, it arose historically because your Lordship knows we had 4 categories of states. We knew we had Raj Pramukhs. That's all very valuable, but it doesn't address the issue. That is, it would have been relevant pre-Prem Kumar Jain. That look, it's a grey area. It's a tabula rasa. Your Lordship has not yet painted on it and decided that UTs under Part 14 are states. Post Prem Kumar Jain, where is the relevance of any history? Because your Lordships were called in only for that reason. Your Lordship had a fight only for that reason before the High Court, which your Lordship resolved. After that, whatever Part 3 state was, we know Ajmer and these other states are all there. What is the point of all that? Now, kindly come to some very interesting rules which are not shown to your Lordship. Your Lordship has shown transaction of business rules for almost 1 hour. Kindly see if any of it is remotely relevant after your Lordship sees 4 rules. I am now in para 3 of my submissions. Transaction business rule only says, generally, what is mine, it is divided like this. What is mine is the operative word. It doesn't say that if I divide it like this, you get what is not yours. But
now, now, Dr. Singhvi, we got your submission. Now, insofar as the All India services are concerned,
that is the rules now coming up.
Right. We'd like you to
straight away. It's about 4 or 5 rules, and in fact, not even 4, 3 rules and 3 paras of mine. These I need to show to your Lordship. Your Lordship has seen it. It will take 2 minutes to show it. May I read it? May I read it first? Allocate para English 3 months, ordinary 3.
Yes, let's read that.
Allocation of all India services, civil servants in respect of Agmut cadre is done by the Joint Cadre Authority and not the Ministry of Home Affairs. Directly shown to your Lordship's Ministry of Home Affairs. That's wrong. It is the Act will apply, then a rule under the Act, then a notification under the rule, or a resolution shown to your Lordships. The resolution is shown for a very different purpose. What your Lordship is told is under a resolution, MHA looks into it. That was a temporary arrangement. Then there were rules, first Act, Section 3, then Rules 4, and then a notification of 25th April 1995. And it's clear that UT is a state. And one more point before I read it. In all these joint cadres, the whole idea, what is the meaning of joint cadre? My reps exist and act and decide as much as their reps. My chief secretary sits there. Joint cadre is collegiate. It doesn't mean he's excluded, but equally doesn't mean I'm excluded. Now let's kindly come. The Joint Cadre Authority is established under Rule 4. Take out the reference. of the All India Joint Cadre Rules of 1972, which are statutory under 3.1. Now, the order is the reverse. 3.1 comes first, then comes Rule 4. Section is 3.1, Rule is 4. The authority is a committee comprising representatives of each of the government of states, constituting the Joint Cadre. The Agmat Joint Cadre has been established under this rule by notification dated 25/4/95. That's the third one. Act, rule, and notification. Whereby Delhi, along with Arunachal, Goa, Mizoram, is represented in the Joint Cadre Authority through its Chief Secretary, whereas the other union territories are collectively represented by the MHA. This distinction itself is important. Delhi has a Chief Secretary sitting there. MHA acts for a few other smaller UTs or whatever your lordship may call them. The function of the Joint Cadre Authority under the All India Rules of 72, the fourth point was, under Rule 5.1, quote, to determine the names of the members of the All India services who may be required to serve from time to time in connection with affairs of each of the constituent states and the period or periods for which their services shall be available to that government. Just pause here, brothers. Look at the bizarre result which is being canvassed before your lordship. Even at the time of allocation, your lordship knows civil services. I am an officer, brothers, of the central service, or IAS. Cadre is, let's say, whatever, UP. Today, from Delhi, some ministry, I am to be posted. At that time itself, a joint cadre will operate for a UT. Where I am sitting, he is also sitting. Look at the bizarre consequence that after I am posted, even at the time of posting, the Chief Secretary has a say. But after I am posted, the state of NCT cannot decide whether to post it with Mr. Farasat, to post it with Mr. Rahul Mehra, post it with Mr. Chadda, or to interchange them every 6 years according to whatever, 6 months according to whatever they want. This I am showing given at inception. Now see those rules. First turn to section 3.1. Bookmark 45, page 3949. Well, with respect, this is actually driving a coach and four through a very well-established harmonious scheme. It's only a question of requiring a lordship's interpretation. I mean, imprimatur, not even interpretation.
3949.
Yes, 3949, bookmark 45. Show me now. Your lordship saw this briefly, but in view of our learned argument, it's very important to see it. In this, your lordship will see, I think rule 4 and 5 is enough. Why does it not go up and down? Do you not scroll? You scroll it for me. Wait. Yes. Wait, let me do. Does my lord have it, please? 3949, All India Services, bracket Joint Cadre Rules of 1972.
Yes.
I want to show 3.1 of the Act. You are not showing 3.1 of the Act.
You have to
Yes.
May I just read 3949 on the top? Has my lords got it?
Yes.
The title is All India Services Joint Cadre Rules of 1972. It is not disputed that things like Agmat, etc. are joint cadres. It's not even disputed. In exercise of the powers conferred by 3.1, this comes at the top. Lordship will note 3.1. It's in the file. I'll give you also the page also. It doesn't have to be read. Act.
Bookmark 9.
The central government, after consultation with the governments of the states concerned, hereby makes the following rules. Well, just mark that section is under the All India Services Act of 1951. It is at page 820, bookmark 9. That section 3(1) is 820 bookmark 9.
Yes, below one tomorrow. Dr. Singhvi, we don't want to rush you. Are you going to finish today or you will spill over a bit tomorrow?
I mean, I don't want to ask Roshi to sit so late. Give me 1 hour tomorrow, I'll finish it off. First, Roshi will assemble here and finish it 1 hour, then Roshi will take your normal.
1 hour more you want?
Well,
He said
I don't want to
90
just,
minutes.
Mr. That's very unfair coming from him.
No, no,
No, not at all.
No, that's
This
a
is
very,
matter of-
I can understand him.
Dr. Singhvi,
My
it's a
learned
matter
friend
of-
argued
we
for
don't
my
want to-
entire
like a
150
civil appeal or a
minutes.
criminal
60
appeal where
minutes
we
became
can stop
150
it
minutes.
And we reach on it.
I am taking into account 150 minutes of argument.
Alright, that's why I asked
in
you
1
that.
hour tomorrow. I'll do it even in 45 minutes tomorrow, first thing in the morning.
It's till 4:15.
Constitution bench, I mean, I have a problem with it. I can't help it. My learned
Dr. Singhvi will time tomorrow.
I'm very deeply obliged.
Keep it first on board
The Lordship assemble first.
One clarification.
and then our regular boards will start.
I'm very deeply obliged.
Only one,
Very deeply obliged.
one clarification. My today's submission may be read in conjunction with the earlier. It's not
Yes, yes.
substitute.
No. Obviously, it's a supplementary.
Supplementary.
We also thought that, Dr. Singhvi, you've made your point. We can also reflect on it. If we have some queries, we can pose you. Otherwise, we will not have the opportunity of posing.
Certainly, certainly.
Can
I
also-
may even take lesser than 1 hour.
We can also now sort of
Your Lordship,
reflect on what has been argued and
Deeply
then-
obliged.
But would my lords be assembling at 10:30?
Yes, yes.
Yeah, we'll take it up at 10:30 only, right? 10:30, you want to do it in
Otherwise, the Lordship, other benches will be impacted.
So we'll keep this matter between 10:30 and 11:30. Then we'll take our mentionings so that my learned brothers and sisters are free for their regular work. And then we'll start with our regular work tomorrow.
Obliged, very, very deeply obliged.
Please,
Brother Narasimha and I will come back for the mentioning.
Just now.
grateful to you.
1 hour, huh? 1 hour.
1 hour.
I will not exceed a minute. Lordship may time me. I'm not going to exceed. Certainly.